He's never done a single thing to anger me or question me having him as a friend. He's always been there for me, which I only recently realized. And how do I pay him back? By ditching him for you, stealing his money, and stabbing his father, who practically treated me as a son. Those are the words that were written by the person who murdered Hans Winter on July 13th, 2008. Those words were written by him, and you've already been introduced to him. He is the defendant, Andrew Galek. He wrote those letters 2 months after he murdered Hans Winter, as Hans Winter lay peacefully in his bed, sleeping. What you will hear and what the evidence will show is that the defendant chose a path. And you're going to hear the many decisions and choices that he makes along the way. But he definitely chose a path. And that path, ladies and gentlemen, was the path that led to murder, and it's the path that leads us here today. That path was filled with pain, pressure, and finally with peril. On July 12th of 2008, the defendant went over to his best friend's house, Kevin Winter's home. And Kevin Winter's home is a tri-level home, and it's in Westminster, Colorado. You're going to hear that this was not an unusual occasion. And in fact, the defendant and Kevin Winter had been best friends and had been friends since they were 6 years old. They went through elementary school together. They went through the pain of middle school together. They went to high school together. And the defendant had spent many, many, many nights at the defendant's home. In his own words, Hans Winter treated him as a son. The Winter family embraced him as a brother. On July 12th, nothing unusual happened. There weren't any angry words between Kevin Winter and the defendant. There weren't any angry words between the defendant and Hans Winter. It was a normal day. Normal. What you're going to hear is that at about 10:30 on July 12th of 2008, Beverly Winter and Hans Winter go to bed. And as usual, Hans Winter calls down and he says to his son, "Good night, Kevin, I love you." He also says, "Good night, Andy, I love you." Kevin Winter did not know at that time that those would be the last words that he would hear from his father. After Beverly Winter and Hans Winter go to bed, the defendant and Kevin Winter go out to Kevin Winter's car. It's about 10:30. And they go out and they get a bottle of tequila. And they take it down into the basement. Remember that this is a tri-level with a basement, so there are 4 levels. Kevin Winter's room is on the bottom level. And you'll hear that they're so close, in fact, that the Winter family has a bed in Kevin Winter's bedroom, and they call it Andy's bed because he stayed over so often. Kevin Winter and the defendant drink tequila. And you're going to hear that they're going shot for shot until about 11:30. Kevin and Winter and the defendant, they play Halo. Kevin Winter plays the cello. And they're drinking. And at one point, Kevin Winter passes out. That is when the defendant takes the opportunity. It's approximately 1 o'clock, a little after 1. And you're going to hear that he makes a decision and a choice. He climbs up 2 small steps to the kitchen. where he gets a knife. He makes that decision and choice. He makes another decision and choice, and he climbs up another set of stairs to the master bedroom. When he gets into the master bedroom, he makes another decision and choice. And he goes over next to Hans Winter's bed. And you're going to hear that Hans Winter slept closest to the door. And he makes another decision and choice. And he raises up a knife. And then he makes the ultimate decision and choice, because he takes that knife and he plunges it with force into Hans Winter. The knife finds its target. It severs the iliac artery of Hans Winter. But something happens that the defendant did not expect. Because Hans Winter screams out, "Why did you hit me, Andy?" And that scream is so startling and so loud for a normally quiet German man that Beverly Winter bolts up out of the bed. She snaps out of the bed, she looks over, and who does she see? She sees the defendant. She sees him backing up and turning around. And he makes another decision and choice, and he runs down the stairs. Beverly Winter is out of her bed, running down the stairs after him. And you'll hear that she's going to describe his clothing, and she's going to describe what his hair looks like. And you're going to see the difference between Kevin Winter and the defendant. She's not more than a few steps away from him. And she is following him down those stairs, 3 small flights of stairs, all the way down to the basement. He goes into the bedroom and sits on the bed, his bed, the twin bed, Andy's bed. And when she rounds the corner, he's sitting on the bed, and he has his head in his hands, and he's sobbing. And he says, "I've ruined everything. I've ruined your life." Beverly Winter is coming down, and remember, it's very important to remember that at this point, she does not know that her husband has been stabbed. She believes he's been hit. And Hans Winter is laying up in bed, and he is slowly bleeding out, ladies and gentlemen. When they get into the room, and Beverly Winter is asking Andy, "Why did you hit Hans? Why did you hit Hans?" She doesn't know what's going on. Kevin Winter is stirred. He gets up, and you're going to hear that she smelled the alcohol. You're going to hear that Kevin Winter is extremely drunk, apologizes for drinking. And while this conversation is going on, Andy lays in the bed, and he begins to kick the back wall with his feet. Beverly Winter says, "What are you doing? Why are you doing that? Why did you hit Hans?" Meanwhile, Kevin Winter is back in his bed, passed out. And the defendant makes another choice. He chooses to run up the stairs. But before he does that, he does something so unusual, something he'd never, ever done before. And he goes over and he hugs Beverly Winter. And as he wraps his arms around her and hugs her, he says, "I'm so sorry." Beverly Winter still does not know that her husband has been stabbed. He runs up the stairs to the kitchen again. She runs after him, only a few steps behind. He goes into that kitchen and he makes another decision and choice. And he opens up one drawer, doesn't find what he's looking for there, opens up the second drawer, he finds another knife, holds it in his hand. At this moment, Beverly Winter, this is the first time she becomes really afraid. But not just afraid for herself, but afraid for the defendant. She doesn't know what he's going to do. And she lowers her voice, and he says to her, "Don't worry, I'm not going to hurt you." And as she's trying to talk to him, telling him, "We'll work it out, whatever's going on with you, we'll work it out," She goes over to the back door and she opens up that back door. And the defendant makes another decision and choice, and he runs out that back door. She closes the back door and locks it. At this point, we have a 17-year-old with a knife in the backyard. And Beverly Winter still doesn't know that her husband's been stabbed. She thinks he's been hit. She's concerned, and she picks up the phone and she calls 911. You're going to hear that 911 call, ladies and gentlemen. And you're going to hear that she tells the dispatcher, I've got possibly a suicidal teen out back. I don't know what's going on. You're going to hear the grisly detail of her finding out that her husband's been stabbed, because while she is on that call, she sees her husband with blood coming from his abdominal area. You're going to hear that 911, and it is chilling. The shock, the dismay in her voice, the concern. And the defendant then makes another choice. What he does is he leaves the backyard and he runs. And you're going to hear he runs down the street approximately 6 blocks away. And he makes another decision and choice. He decides to hide underneath the truck. That is where he is found. And when he is found underneath that truck, several officers are there and they're yelling at him to come out from under that truck. And he makes another decision and choice. That decision is to get out from under the truck, but he doesn't make it right away. He makes that choice when officers threaten to tase him. Only when the officer tells him that if he doesn't come out, they're going to tase him, then he decides to come out from under the truck. You're going to hear that the 2 knives were found. The one knife used on Hans Winter, found it on the twin bed where the defendant was moments after the stabbing. You're going to find out that the second knife was also found where they arrested him. Both knives found. The pain that drove him to do these things. You're going to hear that Melissa Catt, his girlfriend, and the defendant went through a breakup in about February of 2008. The defendant didn't have very many friends. In fact, only 2, Melissa Catt and Kevin Winter. He hung out with a lot of people, but nobody close to him like those 2. And he was in pain from that breakup. She kicked him to the curb for another man. That was painful for him. And the other area that was painful for him was the fact that Kevin Winter and his friendship was beginning to change, grow apart. Kevin Winter was on a different track than the defendant, and they had begun to grow apart. Loneliness, pain, jealousy, envy, all the emotions, all the pain that gave him the vehicle to commit this murder. You're going to hear about the pressure. In the same letter that I told you earlier he had written to Melissa Catt, the defendant details his darkest desire to kill. I shouldn't be dead. I should be dead in my own bed after a murder spree with you by my side. I've never had this deep an urge to murder. I just want to kill and kill and kill. And you're also going to hear that he says the only time he can be happy is when he looks into somebody's eyes and realizes he can destroy them. That dark pressure, that dark, deep desire, fueling this murder. And peril, the peril of substance abuse. And you're going to hear that both the defendant and Kevin Winter were very drunk, very, very drunk. And that gave him that liquid courage to go ahead and murder Hans Winter that night. to carry out his deepest, darkest desire, because it was there. And make no mistake, ladies and gentlemen, you're going to hear that the decisions and choices that the defendant made on that particular night were exactly that, decisions and choices that he made. You're going to hear that he was a practiced drinker. This was not the first time that he drank. He was perfectly aware of the choices he was making on that night. When he killed Hans Winter, his best friend's father, the man, according to him, that treated him like his own son, the family that he betrayed, who treated him like a brother, the deep, dark, perilous, pressured path to murder. When we've proven our case beyond a reasonable doubt, I'm going to ask you to hold the defendant responsible for the decisions and choices that he made on that night. The decision and choice to go down that path to murder. And I'm going to ask you to find him guilty of first-degree murder. Thank you.
Mr. Crew.
May it please the court. Ladies and gentlemen, this case is about evidence, and the devil in the evidence is in the details of the evidence. So let's talk a little bit about what you're going to learn. You're going to learn that Andy Galek and Kevin Winter were best friends from the first grade. They went all the way through school together, and they were best friends throughout. Now, they had different tracks. Kevin Winter was into Boy Scouts, and Andy Galek, after a while, wasn't into Boy Scouts. They had some similar tracks. Kevin Winter wanted to play the cello, and Andy Galek played the cello for a while, not as long as Kevin. They became best friends, and they hung out together and spent time together. Like all long-term relationships, there was sometimes an ebb and sometimes a flow. In this particular case, in July of 2008, it was getting better for Andy Galek. Had broken up with his girlfriend, Melissa Catt. And the relationship between Kevin Winter and Andy Galek was starting to heal itself, for you'll hear that while Kevin Winter was friends with Melissa Catt, it wasn't the kind of relationship he liked very much. So when Andy Galek broke up in February, Kevin and Andy started spending more time together. Now, it's Saturday night. At 7 o'clock, like kids these days, there's some texting going on, and you'll see those texts. And the text comes from Kevin Winter to Andy Galek about 7 o'clock at night. Hey, you want to get blasted? Now, blasted meant alcohol. They had been drinking together before, but this was a night that they wanted to get blasted. You'll see Andy Galek text back and said, blasted, I'm unfamiliar with the term, in joke. Do you got any liquid? And so they made arrangements. Kevin Winter drove over in his truck, picked up Andy Galek at his friend's house. Mom comes out, Miss Galek comes out and waves. The boys are going to spend the night over at Kevin Winter's house, which happened very often, more as youngsters, but still once a month or so as adults. They go down and find a friend who has a fiance, and they go and get a bottle of tequila. Now, you'll hear that this is the first time these boys have ever had tequila. Usually they drink vodka. They're 17 years of age. But they get this tequila, and they go back to Kevin Winter's house. They hide the tequila in the truck. They hide it because, of course, they don't want mom and dad to know that they're drinking. They come in, say hi to mom and dad, and they go down to the basement, the kids' rooms, where they spend some time. They watch a funny show called Adult Swim, which is adult cartoons on cable. They play some games, Dark Age of Camelot on the Xbox, and then they start playing Halo. They get there at about 7 o'clock, and they play all the way through till about 10:30. At 10:30 at night, Beverly Winter comes downstairs to adjust the sprinklers. Remember, it's July 2008. She comes down to adjust the sprinklers, and the sprinkler adjustment is in Kevin Winter's bedroom. She talks to him, everything's fine. There has been no problem whatsoever. In fact, Andy Galek, having graduated from high school early, is happy because he's in the process of getting a job. He's just about to get a job at King Soopers, which is going to give him the money to buy a car, to help take care of a car for himself, and also to move out of the house, which is something he's interested in doing. Good night, boys. Hans calls down, good night, boys. And the parents go to bed on the third level of the tri-level. The boys sneak out and get the tequila. 10:30, 10:45. They come back. They drink from the bottle sometimes, trading shots, and you'll hear that they drink about the same. They come back in, they start playing Halo, another Xbox game. They're drinking out of shot glasses, and they're drinking quite a bit. You'll see some scientific tests on Andy Galek that will tell you about how much he had drunk. And they get so drunk that Kevin Winter has no idea of anything that happens this night. He can't help us. For you'll hear Kevin Winter say, at about 1 o'clock, the last thing he remembers is he says to Andy, go to bed, I'm tired, I want to sleep. And he goes to sleep, and you'll hear him testify. The next thing he remembers, at about 9:30 the next night, Sunday night, he wakes up in the hospital with his sister ranting about Barack Obama because he's interested in politics. And you'll see a really experienced streetwise detective in Franco, who goes and talks to him and says, tell me what happened that night. Tell me what happened last night. And you'll hear Kevin say, I have no idea. I remember telling Andy to go to sleep. Next thing, I'm in the hospital almost 12 hours later. And so we know that they're trading shots back and back so that their level of alcohol is about the same. And you'll hear that Andy Galek also has no idea what happened that night. He has no idea. He has nothing to tell you. But he does have little sparks of memory, and here's what he'll say. He'll say that he is drinking with Kevin. He remembers 2 or 3 things. One is Kevin telling him to go to sleep. He remembers being pulled out from underneath a truck. He remembers going to sleep. He remembers being at the police department and going to sleep. And that's all until he gets to the juvenile detention center. He thinks he's there for drinking. And you'll hear what happens when he's told why he's really there and how he feels. As he continues to think, what could it be? What is it? What happened? He has 2 or 3 other little starburst memories. And the starburst memories consistent with alcohol intoxication, almost alcohol poisoning, are he remembers hearing Beverly Winter tell him to calm down. He remembers something about that. He remembers sometimes the lights being off and sometimes the light being on. But that's all he remembers. And so this is a curious case that has more questions than answers. And so with your jury oath, you've become investigators to help us, all of us, decide what really happened here. Let's talk about the questions, because we don't know. First of all, we know that Andy Galek was happy and giddy. We know that he didn't have any fight with any of the Winters. In fact, he and Kevin were on the rebound, putting their relationship back together. In fact, they were friendly, drinking, and you'll hear that they were having a great time for 17-year-olds breaking the law. You'll hear that Andy Galek never had any problem with Hans Winter. He loved him like a father, as Hans loved him. There was never any problem between the two of them, certainly no problem that night. You'll hear from Beverly Winter that they treated Andy like a son, and he treated them with respect and grace. You'll hear that the evidence in this case, again, because we don't have anybody that can tell us what happened, except Beverly Winter, and we'll talk more about her later, we go to the evidence, and so we try to see, is there any evidence here that shows anything? There's a knife. It's a paring knife. It's one of a set. It's generally kept in the second drawer in the Winters kitchen. One of those knives is in the twin bed recovered downstairs by a great criminalist, a guy named Chris Pardo. You'll meet him. He finds the knife, and on the knife there's some clear serum and some blood. It's Hans Winter's blood. There's no fingerprints on the knife. There's no DNA on the knife. We don't know who held that knife. We don't know where that knife came from or where it is. We know that when Andy Galek left the house, and he left the house, he first goes to one kitchen drawer, the first kitchen drawer, and you'll hear Beverly Winter testify about that. He opens the drawer as if he's looking for something, and when he doesn't find it, he closes it and goes to the second drawer. He takes out a sister to the knife that's found in the twin bed. Now, if he wanted a knife, why didn't he take the knife that was in the twin bed? And even more curious, on the table, and you'll see a picture of that, on the table, criminalist Pardo finds yet a third knife that's just lying on the table there for anyone to see. And so we have the question of the knives. We're also going to have some questions about DNA, for I've told you there's no DNA on this knife. Oh, if there had been DNA on this knife, we would know who held that knife, but we don't. And so criminalist Pardo, not content to just wait for that, he goes to the bedclothes that are on the bed that Hans Winter was in when he was stabbed, for someone stabbed him. And there's a slit on the knife, on the bed sheet. Now, if you put your hand on a knife through the bed sheet, and your hand goes through the sheet into a person, and your hand touches the bed sheet, there's touch DNA that ends up on the bed sheet. And so criminalist Pardo, certified hotshot, says, I'm going to swab that and test it and see whose DNA is there. You know whose DNA is there? Beverly Winter and perhaps Kevin Winter. You know who's excluded by the billions? Andy Galek. And so the criminal evidence, the physical evidence, gives us more questions than answers. And so then we come to Beverly Winter, because I tell you, when she testifies, she's the key to this case, and you need to think about her situation and why we're here. She gives several statements. The first statement she gives is to an officer named Russell. And that's a street cop who's arriving on the scene, and he talks with her. And she tells him, I awoke. Why are you hitting me, Andy? A loud scream from a quiet man. And as she wakes up, she sees, she says to Russell, Andy Galek standing by the side of the bed. Later, she changes that. She tells Detective Infranca, first she sees him by the side of the bed, and when Detective Infranca starts questioning her about that, she says, well, maybe not by the side of the bed, maybe in the door. Maybe in the doorway. Maybe I saw him when he was leaving. And then the question is, imagine you're Beverly Winter, your paralyzed, partially husband. He'd had a stroke years before and was in terrible pain. He's taken Tegretol for pain relief and a number of other things, and it was getting worse. He told Kevin Winter that it was like having spikes driven into him. Why are you hitting me, Andy? She gets up. She doesn't turn on the light. She doesn't tend to her husband. There's a telephone. You'll see a telephone, a cordless phone, right on the nightstand within inches of where Hans Winter was. She doesn't pick up the phone. Neither does Hans. Hans Winter can talk because, why did you hit me, Andy, according to Beverly Winter? But she runs downstairs. And she runs downstairs and she confronts the boys, she says, because neither one of the boys remembers anything. She says she confronts the boys in the bedroom. Now she says, I don't see any knife, and then later tells Detective Frank he must have thrown the knife someplace. She doesn't see any knife, even though she says Andy Galek is laying on a bed crying and kicking. And you'll hear from criminalist Pardo that he has no evidence of anybody kicking any walls. And so she says, what's going on? And she knows that her son, Kevin Winter, is really drunk. She says maybe hallucinating. In fact, she says, I think they were both hallucinating. And in her first statement, she says that Kevin Winter comes and hugs her. She doesn't say anything about Andy Galek hugging her. And then in her second statement, July 15th, she's talking with Detective Infranca, and she says, oh, and I forgot something. Andy also got up and hugged me, which was very unusual. In her first written statement, you'll wait and hear in vain, because in the written statement, she doesn't say anything about, and this is that very evening, she doesn't say anything about, why did you hit Hans, Andy? Why did you hit Hans? She doesn't say anything about that in the first statement. Now imagine if you're running downstairs in the middle of the night when your husband said your surrogate son had hit you, that's the first question you'd ask. In her written statement, she says no. And then there's a long statement, again on the 15th, with Detective Infranca. And Detective Infranca spends a great deal of time with her. And is there any statement in there from Beverly Winter? Why did you hit Andy? No. That only comes up when we have our first court appearance, August the 1st. And she says, oh, and I asked him, why did you hit Hans? Not once, but twice. And so as we take a look at this case, there are more questions than answers. Now, there's some questions that aren't very hard, and that is there's a 17-year-old in jail charged with murder that he can't remember, that he doesn't know if he did or not. And as he does that, Melissa Catt comes back to him and they exchange letters. And you'll see in this letter, Andy Galek, being held in jail charged with the murder of his best friend's father, writes these foolish lines about why am I here and how did this happen. You'll see the context of that as a 17-year-old kid lashing out. And then we get to the alcohol. You'll find from the criminalists and the forensic toxicologists that both of these boys were stupefied drunk. Kevin Winter was passed out, and so after the police got there, and again, we're talking a matter of minutes, this first 911 calls goes in at 0128, and the first officer is on the scene at 0131. Beverly Winter says that just minutes ago, she and Kevin Winter are conversing. When the officers get there in that short period of time, they find that Kevin Winter is unconscious. So unconscious, they call a second ambulance, and they have to help him to the pram because he's so drunk that he doesn't know what he's doing, who he is, or where he is. And Kevin Winter will say, I thought everything was going well that night. I don't remember. His blood alcohol at the time they took it, and you'll see the numbers, was 0.150, about twice what it is to be able to legally drink or drive. But when they took it, if you do the extrapolations, you'll see that Kevin Winter was probably at about a 0.20. And that, ladies and gentlemen, is dead dog drunk. Now, when they arrested Andy Galek hiding under this truck, and wait till you see how this hiding. His head and shoulders are under the truck, but his torso was sticking out from under the truck. And so people see him getting under the truck and they call the police. And you'll hear something other very curious. There's a neighbor, Miss Taryn. She speaks mostly Spanish, so she has a little trouble with the language. But she says at 1 o'clock in the morning, again, police are called at about 0128. At 1 o'clock in the morning, she wakes up to see two boys outside of the Winter home. And they're goofing around. And they're making some noise. And she has a small child. She's up watching them. She says there's a truck that comes down the street and these two boys hide in the bushes. And then they get up and go back in the house. And she says at about 0130 that same day that one boy comes out She actually calls 911. One boy comes out because he's talking to himself as if he's hallucinating on alcohol or drugs. In that neighborhood, there's a median, kind of an island, and she says it's very curious because the boy lays down on the grass and rolls around in the grass before he gets up and starts walking on down the street towards Carol Butts Park. She calls 911 at about the same time Beverly Winter calls 911. And when Andy Galek gets to the police department, he is so drunk that they have to take him out of the cell, and the officers are worried that he had so much to drink that they send him to the hospital. And they take 2 tests. And the way they do this is everybody metabolizes alcohol at a different level. So they take one test at 0.516 and another at 0.616. 0.516, Andy Galek's blood is at 0.150. 0.616 is at 0.138. So he's metabolizing about 0.12 per hour, plus or minus. It's not an exact science. But if you extrapolate it back, you'll see that he's right close to the 0.20 mark. So is Kevin Winter, and that is stupefyingly drunk. And so, ladies and gentlemen, we ask your help. This case is a difficult case because the nuances and the details are very, very curious and sometimes inexplicable. The big question, of course, is why? Now, the district attorney says that it's decisions. Wait till you hear the evidence. Wait to hear the evidence and see what people have to say. And you'll see how these stories start to slide. It's your job to get to the truth of this, and when we find what the truth is, we'll ask you to tell us. And at the end of this day, I will come back and ask you to find Andy Galek not guilty of first-degree murder. Thank you.
All right, the jurors have left the courtroom, and we can certainly approach this any way that counsel is comfortable with. We can, I'll first deal with the motion that I'm sure will be made on behalf of Mr. Galek.
At this point, we're going to review our Rule 29 motion. The standard is a little bit different, although not all that much. Again, we incorporate the argument we made previously. Your Honor, I believe that there's no evidence of deliberation as defined by the statute that's present in this particular case. We'd ask the matter be sent to the jury on second-degree murder.
Mr. Maritzky, or Ms. Warner, whoever's going to make the argument.
Judge, while I understand defense counsel is indicating probably that defendant's taken the stand, I think it's still for the jury to determine whether or not the deliberation was there based on the circumstances of the case. And I know while the defendant says he doesn't remember anything, I don't think that sheds any light on it. So I think we're at the same place we were at halftime, essentially. So I would ask the court to deny defense counsel's motion.
All right. As stated, the standard is a bit different, but substantially the same as when the prior motion was ruled upon. Here, certainly, the jury has more evidence and different evidence to consider. They will have to decide the weight to be accorded to that testimony and the evidence, and make credibility determinations in that regard. The court will incorporate the record that the court made on the earlier motion that was made pursuant to Rule 29, and will again, with respect to the count of murder in the first degree after deliberation with intent, find that there is enough evidence that a reasonable trier of fact, drawing reasonable inferences that they may from the evidence, may find that the act was committed after deliberation and with intent, so the motion will be denied. All right, now we'll get to that point I was talking about. Well, I've been submitted instructions by the prosecution. The court has drafted an instruction that I'll invite counsel. If both of you want to come up, that's fine. If I've got a copy for each side. And it's not complete because I don't know what everybody's going to be requesting, but generally it is the instruction with respect to intoxication, and then the relevant definitions follow that.
I think this is the appropriate instruction.
I agree, Judge, with the addition of, I guess, obviously, which...
Whatever lessers, yes. All right. Well, I'll keep this one and fill in the blanks as become appropriate. And I suppose in the first instance, I will call upon the prosecution with respect to whether you are asking the court to instruct the jurors on any lesser included offenses, rather, of murder in the first degree.
You would, Judge, with the sole count that we would ask the court, sole lesser we'd ask the court to include would be second-degree murder.
All right, and then I will call upon counsel for Mr. Galek to, with respect to the lesser included offenses of first-degree murder and what you're requesting.
Your Honor, we're asking that there be a carry instruction and that the court instruct on second, reckless manslaughter, and criminal negligence.
All right, the position of the people and any argument
Judge,
you'd like to make with respect to the two further lessers underneath murder in the second degree.
Judge, I don't believe there's any evidence of that would support a conviction under reckless manslaughter or criminally negligent homicide. I don't believe there's a scintilla of evidence, and so the people would ask the court not to include those.
All right, with respect to the request for the lesser included offenses of reckless manslaughter and criminally negligent homicide, under 18-1-408-6, the court is not obligated to charge the jury with respect to an included offense unless there is a rational basis for a verdict acquitting the defendant of the offense charged and convicting him of one of the included offenses. The standard is really, the court has to give, I suppose, the benefit of the evidence in that regard to a defendant in the case. And I'll just, I'll tell you where I'm at right now, and I'll allow counsel to make further argument. The evidence is that, and it's, at least some of it is somewhat undisputed at this point, is that the victim was lying in bed on his back, apparently asleep or in a state close thereto, was physically challenged, which would make it difficult for him to defend himself. That's really not the issue so much. He received a single stab wound, although a somewhat deep wound to the abdomen, which caused his death. It was in the dark, I suppose, and there was one stab wound. So I suppose, and just looking at the state of the evidence as it is, that it's possible that one could disregard a substantial and unjustified risk that the result would occur, the result here being death, based upon the conditions in the room, and not to diminish the severity of the wound, but it was one and not several. That being said, I'm having a bit of difficulty going down to the next level of criminally negligent homicide, where one fails to perceive a substantial and unjustified risk that a result will occur or circumstance exists, because, in particular, and based upon the law in the state of Colorado and the case law, certainly there's been intoxication raised in this case, and it's going to be an issue for the jury to decide, but it is not a defense to the general intent crimes. But I'm not stuck there, but I'll entertain whatever argument, and I suppose since Mr. Truman's asking for both of those lessers, I suppose right now I'm leaning toward giving the reckless, and perhaps leaning a little bit toward not giving the criminally negligent homicide, and if perhaps a hypothesis that the court would help the court along from either side would be helpful, I suppose, but I'll call upon Mr. Truman.
Your Honor, I think the only difference in all those counts is the culpable mental state. The culpable mental state, the court's already found that they could find after deliberation. They might find knowingly. Perhaps it's reckless. There's not much of a step from reckless to criminal negligence under these circumstances. There's no evidence here, again, as we've argued in our 29 motions, concerning deliberation. And so a juror could, under these circumstances, find anywhere in this panoply of decisions, because it only goes to what their finding is as to what's in the mind of Mr. Galek. Now, just the fact that self-induced intoxication is no affirmative defense does not relieve the people of their burden to show the proper culpable mental state.
Mr. Maritzky, Ms. Warner.
And Judge, I can't conceive, I guess this is the does it strain credibility test, and I don't know if the court or counsel can conceive of a method by which someone can be criminally negligent and to go into another individual's room that they're not invited into in the middle of the night with a knife, plunge that knife into them, and have the culpable mental state of disregarding a risk. So, Judge, I think that's just the argument is it strains credibility to put somebody in that position and say that that was a negligent act. And if counsel can conceive of that particular argument, that there's a possibility of that. In fact, I would argue that the case with the reckless. I think to have to say, you have to say you consciously disregarded that risk, and I don't think there's been any evidence of that. It's either he did it, he knew he did it, or, as he said, he didn't know anything that he did. So for both of those, Judge, I think it's a balancing test on the facts of this case.
All right, this is what I'm going to do. We've all had a long day. We've worked hard. I was trying to work hard to get it to the jury perhaps today. It just didn't work out that way. So we're coming back tomorrow. I will admit, I'm a little weary. It's been a long day. What I'm going to ask from the prosecution I suppose, unlike Mr. Truman's comment at the bench, of which I think he was joking a little bit. I'm very concerned about instructions, and I have to be. Even to the point where I care about fonts. The fonts on the instructions, because I want them all to look the same, to look like one of them doesn't stick out from the other ones. So what I'm going to ask the prosecution to do, I can fix and I will, under both versions. The court is going to give the reckless manslaughter instruction. What I want to ponder when I go home tonight and when I get enough energy to read a little bit more of the case law in that area. So my decision is going to be whether or not to do the bridge to criminally negligent or not. I am going to give a reckless manslaughter instruction. So if perhaps you folks can get me the bridge, both versions and both verdict forms, I'd appreciate that.
You're asking the people to provide that as opposed to the defense?
I am. And, under most circumstances, I would do it. But as I said, I'm a little weary. And I didn't spend a whole lot of time with my family last night because I was listening to audio tapes and reviewing things. So I'm going to try to spend a few lucid moments with my 3-year-old tonight. If you really object to that, I suppose I'll go do it.
No, Judge. The court's asking me to do it. The people will gladly do it.
All right.
Judge, we could do a whole packet of instructions with our font if the court wishes.
No. All right. The only thing that might put a press on things is I'd perhaps like to have them, and I think we're right on the word processors, and I have them too. But if we could endeavor to maybe get them by 8:15 or so, 8:30 at the latest, because it will take a half an hour to get them printed out for the jurors. I do them two-sided, the copies I give to the jurors and to counsel. And I suppose the next issue that I'm going to cross is any other instructions that are being requested on behalf of Mr. Galek. We have a theory of the case or anything of that nature that differs from what is in the packet that I've been provided. And of course, I will take out the defendant not testifying.
The only other instruction that I would have tendered is the definitions of self-induced intoxication. The court preempted that one. I have no other additional instructions to tender.
All right, any from the people?
I don't believe so, Judge. I am going to ask the court, you're doing the intoxication,
yes.
And we're doing all of these in Times Roman in a 14 font?
That's what I'm trying to do. I wasn't sure what font this was, so I was experimenting, which
it was a Times New Roman 14 font for the people's.
Okay. And the only other thing, I don't really care one way or the other whether I stick a cover page on anything or not, but if I am going to put a cover page on it, I would like to say Division G. If you don't feel like changing that, I will just, because this one says E and this is Division G, and I like the record to be at least as clear as we can make it, but I don't mind just giving copies without a cover page. So. All right, anything else before we break for the evening? Or are you folks going to be able to figure out with number 1 what we're going to call Exhibit X, the audio tape?
I would just ask to label it as one of our numbers. We'll play it. We're going to be playing it probably in closing argument, or we can tell them before. We can tell them before the close. Or you can tell them that the conditionally admitted exhibit is people's exhibit number, and we'll put it.
Get me a number by tomorrow morning.
We will do that, and I guess we're asking, since the court asked us before, defense counsel and myself will sit down and play this to make sure that there's no issues.
That's fine.
It's one.
Okay.
And the last thing.
It's exhibit number 115, Judge. Sorry to interrupt.
115?
115.
All right. Well, I'll let you folks commiserate on that. And the last thing I suppose I will need is there was a stipulation that the court really didn't formally read into the record. It was really kind of explained by counsel, and the court accepted it. In most circumstances, what the court does with stipulations is I formally read it into the record. And then I just give them the normal stipulation, the parties have stipulated to something and you can treat it as a fact. What perhaps we should do in this case is we'll just do a written instruction that kind of puts those two together. In other words, that it spells out your stipulation and then that you're to treat that as a fact that is proven. Because I probably should have asked for it, or I probably should have given them that instruction here, but I was a little unclear about it. I figured that Mr. Kevin Winter had received the test because he was taken to the hospital, but I wasn't sure about what time or whether there's any issues as to that. So if you could get that to me by hopefully 8:30 tomorrow morning so we can get these printed up. All right, anything else before we break for the evening, folks?
Not from the people.
Good trial. All right, the court is going to recall People v. Galek, that's 08CR 2007. The court has copied the jury instructions for the jurors. Hopefully has provided a copy to counsel as well, the two-sided copies. I'll let the jury know that so they can read along. Anything before the jury comes in, Ms. Alatorre is on her way down to bring them up.
Judge, we would just ask the court before reading the instructions to instruct the jury that People's Exhibit 1, that the audio recordings that were previously admitted are People's Exhibit 115.
All right, this one, I'm just going to let them know that People's 115 has been admitted in this case. I'll let one of you during close tell them what it is.
Thank you, Judge.
Okay, well, I didn't hear from Mr. Truman, so.
I met the court, Your Honor.
All right, let's bring the jurors in. All right, the jurors are all back and in their seats. In case number 2008 CR 2007, People v. Andrew Galek. Ladies and gentlemen of the jury, thank you for your patience. Each of you should have a copy of the instructions of law that the court is going to read to you in just a moment. They're two-sided copies, so you need to flip them over if you wish to read along with the court as the court reads the instructions to you. Members of the jury, the evidence in this case has been completed. In a moment, I will read you the law you must apply in order to reach your verdict. But first, I want to mention a few things that you need to keep in mind when you are discussing this case in the jury room. It is my job to decide what rules of law apply to the case. While the lawyers may have commented during the trial on some of these rules, you are to be guided by what I say about them. You must follow all of the rules as I explain them to you. Even if you disagree or don't understand the reasons for some of the rules, you must follow them. No single rule describes all the law which must be applied. Therefore, the rules must be considered together as a whole. During the course of the trial, you received all the evidence that you may properly consider to decide the case. Your decision must be made by applying the rules of law which I give to you to the evidence presented at trial. Neither sympathy nor prejudice should influence your decision. If you decide that the prosecution has proved beyond a reasonable doubt that the defendant committed the crime as charged, it will be my job to decide what the punishment will be. You should not try to guess what the punishment might be. It should not enter into your consideration at any time. At times during the trial, lawyers made objections to questions asked by other lawyers and to answers by witnesses. Do not draw any conclusions from such objections or from my rulings on the objections. These only related to the legal questions that I had to determine and should not influence your thinking. If I told you not to consider a particular statement, you are told to put the statement out of your mind, and you may not consider any statement in your deliberations which you may have been instructed to disregard. Finally, you should consider all the evidence in the light of your observations and experience in life. Instruction number 2. The defendant is charged with committing the crime of murder in the first degree in Adams County, Colorado, on or about June 13th, 2008. The defendant has pleaded not guilty. Instruction number 3. The charge against the defendant is not evidence. Instruction number 4. Every person charged with the crime is presumed innocent. This presumption of innocence remains with the defendant throughout the trial and should be given effect by you unless, after considering all the evidence, you are then convinced that the defendant is guilty beyond a reasonable doubt. The burden of proof is upon the prosecution to prove to the satisfaction of the jury beyond a reasonable doubt the existence of all of the elements necessary to constitute the crime charged. Reasonable doubt means a doubt based upon reason and common sense, which arises from a fair and rational consideration of all of the evidence, or lack of evidence in a case. It is a doubt which is not a vague, speculative, or imaginary doubt, but such a doubt as would cause reasonable people to hesitate to act in matters of importance to themselves. If you find from the evidence that each and every element has been proven beyond a reasonable doubt, you will find the defendant guilty. If you find from the evidence that the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt, you will find the defendant not guilty. Instruction number 5. There are 2 types of evidence from which you may properly find the truth as to the facts of a case. One is direct evidence, the other is circumstantial evidence. That is, the proof of facts from which other facts may reasonably be inferred. The law makes no distinction between direct and circumstantial evidence. Instruction number 6. The mere number of witnesses appearing for or against a certain proposition does not, in and of itself, prove or disprove said proposition. Instruction number 7. You have heard witnesses who have testified as experts. You are not bound by the testimony of experts. Their testimony is to be weighed as that of any other witness. It is entirely your decision to determine what weight shall be given their testimony. Instruction number 8. When a witness in a criminal trial has made a previous statement which is inconsistent with his testimony at trial, the previous inconsistent statement is admissible not only for the purpose of impeaching the testimony of the witness, but also for the purpose of establishing a fact to which his testimony and the inconsistent statement relate. Instruction number 9. You may have to decide what testimony to believe. You should carefully consider all of the testimony given and the circumstances under which each witness has testified. Consider each witness's knowledge, motive, state of mind, demeanor, and manner while on the stand. Consider the witness's means of knowledge, ability to observe, and strength of memory. Consider also any relationship each witness may have to either side of the case, the manner in which each witness might be affected by the verdict, and the extent to which, if at all, each witness is either supported or contradicted by other evidence in the case. You should consider all facts and circumstances shown by the evidence which affects the credibility of the witness's testimony. You may believe all of the testimony of a witness, or part of it, or none of it. Instruction number 10. Evidence of a defendant's flight may be relevant to show consciousness of guilt, but only if it can be shown that the defendant was aware he was being sought. Instruction number 11. The parties have agreed that Kevin Winter was taken to the hospital and that a test of his blood alcohol level was obtained at 5:00 a.m. on July 13, 2008. The result of that test showed Kevin Winter's blood alcohol level to be 0.159. You should consider this stipulation as a proven fact. Instruction number 12. The elements of the crime of murder in the first degree are: 1, that the defendant; 2, in the state of Colorado, at or about the date and place charged; 3, after deliberation and with intent; 3A, to cause the death of a person other than himself; 3B, cause the death of Hans Joachim Botho Winter. After considering all the evidence, if you decide the prosecution has proven each of the elements beyond a reasonable doubt, you should find the defendant guilty of murder in the first degree. After considering all the evidence, if you decide the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt, you should find the defendant not guilty of murder in the first degree. Instruction number 13. A defendant may be found guilty of any lesser offense if the evidence is sufficient to establish his guilt of a lesser offense beyond a reasonable doubt. The evidence in this case may establish the offense of murder in the second degree, reckless manslaughter, or criminally negligent homicide. The elements of murder in the second degree are: 1, that the defendant, 2, in the state of Colorado at or about the date and place charged, 3, knowingly, 4, caused the death of another person. The elements of the crime of reckless manslaughter are: number 1, that the defendant, number 2, in the state of Colorado at or about the date and place charged, 3, recklessly, 4, caused the death of another person. The elements of the crime of criminally negligent homicide are: 1, that the defendant, 2, in the state of Colorado at or about the date and place charged, 3, caused the death of another person, 4, by criminal negligence. You should bear in mind that the burden is always upon the prosecution to prove beyond a reasonable doubt each and every element of any lesser offense. The law never imposes upon a defendant in a criminal case the burden of calling any witnesses or producing any evidence. After considering all the evidence, if you decide the prosecution has proven each of the elements of the crimes charged or of a lesser offense, you should find the defendant guilty of the offense proven and should so state in your verdict. After considering all the evidence, if you decide the prosecution has failed to prove any one or more of the elements of the crimes charged or a lesser offense, you should find the defendant guilty of the offense proven and so state in your verdict. While you may find the defendant not guilty of any or all of the charges, the defendant may only be found guilty of one of the following: murder in the first degree, murder in the second degree, reckless manslaughter, criminally negligent homicide. Instruction number 14. A crime is committed when the defendant has committed a voluntary act prohibited by law accompanied by a culpable mental state. Voluntary act means an act performed consciously as a result of effort or determination. Culpable mental state means after deliberation, intentionally or with intent, or knowingly, or recklessly, or with criminal negligence, as explained in this instruction. Proof of the commission of the act alone is not sufficient to prove that the defendant had the required culpable mental state. The culpable mental state is as much an element of the crime as the act itself and must be proven beyond a reasonable doubt, either by direct or circumstantial evidence. After deliberation means not only intentionally, but also the decision to commit the act has been made after the exercise of reflection and judgment concerning the act. An act committed after deliberation is never one which has been committed in a hasty or impulsive manner. A person acts intentionally or with intent when his conscious objective is to cause the specific result proscribed by the statute defining the offense. It is immaterial whether or not the result actually occurred. A person acts knowingly with respect to conduct or to a circumstance described by a statute defining an offense when he is aware that his conduct is of such nature or that such circumstance exists. A person acts knowingly with respect to a result of his conduct when he is aware that his conduct is practically certain to cause the result. A person acts recklessly when he consciously disregards a substantial and unjustified risk that a result will occur or a circumstance exists. A person acts with criminal negligence when, through a gross deviation from the standard of care that a reasonable person would exercise, he fails to perceive a substantial and unjustified risk that a result will occur or that a circumstance exists. Instruction number 15. You may consider evidence of self-induced intoxication in determining whether or not such intoxication negates the existence of the elements of after deliberation and with intent or intentionally. The prosecution has the burden of proving all the elements of the crimes charged beyond a reasonable doubt. If you find that the defendant was intoxicated to such a degree that he did not have the mental state of after deliberation and with intent or intentionally, which are required elements of the crime of murder in the first degree, you should find the defendant not guilty of this charge. The defense does not apply to the crimes of murder in the second degree, reckless manslaughter, and criminally negligent homicide. Self-induced intoxication means intoxication caused by substances that the defendant knows or ought to know have a tendency to cause intoxication, and that he knowingly introduced or allowed to be introduced into his body. Intoxication means a disturbance of mental or physical capacities resulting from the introduction of any substance into the body. Instruction number 16. If you find the defendant not guilty of murder in the first degree and the lesser included offenses, you should disregard this instruction. If, however, you find the defendant guilty of criminally negligent homicide, then answer the following question. Did the defendant commit the offense against an at-risk adult? At-risk adult means any person who is 60 years of age or older, or any person who is 18 years of age or older and is a person who is impaired because of the loss of the use of a hand or foot. It is the prosecution's burden to prove this element beyond a reasonable doubt. After considering all of the evidence, if you decide the prosecution has proven this element beyond a reasonable doubt, you should indicate yes on the form that's been provided. After considering all the evidence, if you decide the prosecution has failed to prove this element beyond a reasonable doubt, you should indicate no on your verdict form that has been provided. Your finding must be unanimous. Instruction number 17. In a moment, you will receive the final arguments of counsel. At the conclusion of final arguments, the bailiff will escort you into the jury room. Upon reaching the jury room, you are first to select one of your members to be the foreperson of the jury. Your foreperson shall preside over your deliberations and sign whatever verdict you reach. The verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree to it. Your verdict must be unanimous. Only one portion of each verdict form shall be returned signed for each count, and the verdict form and these instructions shall remain in the possession of your foreperson until such time as they are called for in open court. Upon reaching your verdict, you will inform the bailiff of the court, who will in turn notify the court, and you will remain in the jury room until called into the courtroom. You will be provided with one form of verdict. When you have unanimously agreed on your verdict, you will select the portion of the verdict form which reflects your verdict, and the foreperson will sign it as the court has stated. The unsigned portion shall be returned with no markings on it. After the reading of these instructions, the court will read you the form of verdict that you will receive. You are further instructed that no inferences are to be drawn from the order in which the court reads the verdicts. All right, the court has the verdict and special interrogatory forms. You will receive one of them when you go back into the jury room, and I'll read those to you now. Jury verdict, count 1, murder in the first degree, people of the state of Colorado v. Andrew Michael Galek. Roman numeral number 1. We, the jury, find the defendant, Andrew Michael Galek, not guilty of count number 1, murder in the first degree, and the lesser included offenses of murder in the second degree, reckless manslaughter, and criminally negligent homicide. Underneath that is a signature line for the foreperson. Roman numeral number 2. We, the jury, find the defendant, Andrew Michael Galek, guilty of, and there are 4 boxes that may be checked, but only one may be checked. The first one reads murder in the first degree, the second, murder in the second degree, the third, reckless manslaughter, and the fourth, criminally negligent homicide. Underneath that, a signature line for the foreperson. The foreperson should sign only one of the above, Roman 1 or Roman 2. If the verdict is not guilty, then Roman 1 above should be signed. If the verdict is guilty, then Roman 2 above should be signed. There are double asterisks by each of the boxes I described earlier. If you find underneath the double asterisk at the bottom, if you find the defendant guilty of the crime charged or one of the lesser included offenses, the foreperson must complete this guilty verdict by placing in ink an X in the appropriate square. Only one square may be filled in with the remainder to remain unmarked. And then there's a special interrogatory, and it reads the same. People of the state of Colorado v. Andrew Michael Galek. Reads as follows. If you find the defendant, Andrew Michael Galek, not guilty of murder in the first degree and the lesser included offenses, do not answer the following interrogatories. The next paragraph reads, if you find the defendant, Andrew Michael Galek, guilty of criminally negligent homicide, you must answer the following interrogatories by answering yes or no to each individual question. Underneath that, it reads, we unanimously find that, Roman 1, the defendant committed the offense against an at-risk adult, and there's a box for yes and a box for no. Roman numeral number 2, the victim was over 60 years of age. Again, a box for yes, a box for no. And Roman numeral number 3, the victim was a person that was impaired because of the loss of or permanent loss of the use of a hand or foot with a yes or no. Underneath that is a signature line for the foreperson. Furthermore, I will inform you that exhibit number 115 was admitted in this case, and I'll allow counsel to explain that to you. With that, I will turn it over to the prosecution. I intend to allow approximately 45 minutes for the closing arguments.
At the beginning of the case, I told you that this was a case about choices and decisions. That has not changed. That's precisely what this case is about. It's the resounding theme in this case, choices and decisions. I'm going to walk through some of the choices and decisions made by the defendant on this particular night, and I want to be able to demonstrate to you how his choices and decisions, how the evidence in this case shows that he absolutely committed murder in the first degree. So let's start. The evidence in this case I want to turn to, first of all, reckless manslaughter and criminal negligent homicide. So let's turn to instruction 13 if you want to follow along. The elements in the crime of reckless manslaughter are that the defendant in the state of Colorado recklessly causes the death of another person, or that the defendant in the state of Colorado causes the death of another person by criminal negligence. Ladies and gentlemen of the jury, this is not reckless manslaughter, and it furthermore is not criminally negligent homicide. How do we know that? We know that because of this, ladies and gentlemen. This is a stab wound. Could I have 96, please? This is a stab wound created when Mr. Winters was stabbed in the middle of the night. It's not an accident. The defendant doesn't fall from the ceiling onto him with this knife. And how do we know it's this knife? Well, that's relatively easy as well. If it walks like a duck and quacks like a duck and looks like a duck, it's a duck. This particular knife is the same width, but not only that, what else do we have? We have evidence that Mr. Winters' DNA is on that knife, that his blood is on that knife. And I want you to remember what Dr. Arnold told you. Doesn't have to be a lot of blood. Doesn't. This is the knife that was found in the twin bed where the defendant had been laying moments before, after he ran down the stairs. This, ladies and gentlemen, was a wound that was forcefully done. This is not reckless manslaughter. He did not act with conscious disregard to a substantial and unjustified risk. That's not what he did here, and it's not reckless manslaughter. He did not act with criminal negligence. He didn't act with a gross deviation from a standard of care. A standard of care going into somebody's bedroom in the middle of the night and then stabbing them with a knife forcefully. It's not reckless manslaughter. It's not criminally negligent homicide. If you did find that it was reckless manslaughter or criminally negligent homicide, we would also need to prove to you, as to the criminally negligent homicide, that he is an at-risk individual. Clearly, he was over the age of 60. He's at risk. So if you did find criminally negligent homicide, you could check mark that box off, yes. He was over 60 years of age. That's been proven. But really, that's not what this case is about. This case is really about the decision between whether the defendant committed the crime of murder in the first degree or murder in the second degree. That's where the crux of this case lies. And I want to dispose of the elements of the offense that aren't at controversy here. So let's go through those. Let's go to instruction number 12. Also place your finger back on that instruction number 13. Now, instruction number 12 says to you that the defendant in the state of Colorado, at or about the date and place charged, after deliberation and with intent to cause the death of another person other than himself, caused the death of Hans Joachim Botha Winter. Well, ladies and gentlemen of the jury, as I said, we're going to dispose of the things that are not at controversy here. Not at controversy that's happened in Colorado. Plenty of testimony about that. Not at controversy that it's Mr. Botha Winter who's dead. That's not a controversy. It's really not a controversy that he was stabbed, and as a result of that stab wound, he died. All those things we can set aside. What's at controversy here, ladies and gentlemen? What's at controversy is that it was the defendant, first of all, and second of all, if he was capable of forming specific intent to be able to commit this crime. So let's talk about those two things. First of all, how do we know it was the defendant? Let's turn to that. How do we know that it was him? Well, first of all, we know it was the defendant because Mr. Winter tells us that, right? He screams out in the middle of the night, "Andy, why did you hit me?" He tells you himself that it was the defendant. How else do we know that? We also know that through Beverly Winter's testimony. And even the defendant admitted to you that she says what she knows. He's seen her testify now 2 times by the time he takes the stand. He's also seen her interview. She testified to what she knew. And what did she know? She knew it was the defendant. She could recognize him. He stayed at her house overnight. That's another way we know it's the defendant. How else do we know it's the defendant, though? We know it because he tells us. He tells us in his own words. He tells us that when he sends the letter to Ms. Cat. And he sends 2 letters to Ms. Cat. He sends one on September 7th and the next one on the 15th. And if you read these letters, you go back and you read these letters, they're his own words best describe what he admits to doing. His own words against him. His own words, even better than the words of Mr. Winter screaming out in the middle of the night. He says he stabs him. He tells you about that deep, dark desire to kill. His own words, ladies and gentlemen. That's also how we know that the defendant committed this crime. We also know from his own voice. People's Exhibit 115 contains recordings of the defendant's calls. He knew he was being called and recorded. He knew that. And you need to go back and listen to those calls. Specifically, listen to the one where he says to Melissa Catt, what he did was violent, not crazy. It's violent, not crazy. And when you listen to that, those recordings, I want you to keep into consideration in the back of your mind what his demeanor like was here on the stand. Quiet, shy, not the same on the phone. And not only does he follow up with, it was violent, not crazy. And what does he say next? Shut up, you're incriminating me. How do you know you're being incriminated? Unless you understand you've committed that crime. So let's talk about intent and after deliberation a moment. Let's talk about that. How do we know that he did this crime after deliberating with intent? How do we know that? We know that for a couple of reasons. First of all, we know that he does this with intent and after deliberation because of his actions. Because of his actions. He tells you he goes over and he spends the night with Mr. Winter. And they're drinking. They're drinking. And they don't stop drinking, he says, until about 1 o'clock, right? And somehow or another, at 1 o'clock, fortuitous enough that Kevin Winter has passed out. And the defendant knows Kevin Winter's a lightweight compared to him because he's been drinking a while. He ends up in the upstairs bedroom, in the master bedroom. And he ends up in that bedroom with a knife, ladies and gentlemen. He has to climb the stairs out of the basement. Decisions and choices, each step, each time. He not only has to climb up this flight of stairs, he goes up another smaller flight of stairs, and finally, he goes up this flight of stairs. Each step, each decision, each choice. What else demonstrates his intent to do this crime? Let's talk about the fact that he does this at night. He does it at night when the Winters are asleep in their bed. He doesn't go up there during the daylight hours. He goes at night, waits. It's nighttime. But let's talk about his choice of clothing, shall we? This is Mr. Galek when he is found. This is what he's wearing. He's wearing a black shirt, black pants, and black boots. His choice of clothing is very interesting. It's nighttime, it's dark, it's in a home. Remember what Beverly Winter tells you. She thought it was strange that he was wearing a black t-shirt because he doesn't wear t-shirts. In fact, what she says is both Kevin Winter and the defendant wear these hoodies. It's the summer, it's hot. They're wearing hoodies. And in fact, if you look at the bed where the knife is found, where the defendant is found, what do you see? See black shirt there. And in fact, in Kevin's bedroom, there's also his hoodie on the chair. Why doesn't he wear his hoodie up the stairs? Let's think about that for a minute. He never wears a t-shirt, remember? Intent. After deliberation. He knows if he wears that hoodie and he goes up those stairs and he stabs Mr. Winter, pretty hard to get blood out of a shirt. Not so much off your hand. With intent, after deliberation. But what else does the defendant do on that night that leads us to believe that he acted after deliberation and with intent? What else? What else does he do? Well, Miss Winter tells you that she's not a very light sleeper. She wouldn't hear the door open. But it's interesting that when he goes into that room, he's stealthy enough to stand next to somebody's bed. She never hears him come into the room. He's got those boots on, ladies and gentlemen. She never hears him come into the room. She never hears him come into the room because that's exactly what he's doing. He's being quiet deliberately. If you're going to stab somebody, if that is what your intent is, to stab them and kill them, you're going to be stealthy. With intent, after deliberation. Finally, ladies and gentlemen, we have his words against him yet again. In the calls, remember when he talks to his girlfriend about where the police station is? You're going to hear that call. And she says, yeah, that's where I had my interview. It's a police station. It's over here. And he says, well, I didn't plan that very well, did I? Listen to his words. Listen to the way he states it. With intent, after deliberation. And look at his own words again against him. You're the only one who could understand a feeling like that. A feeling like that. He tells you it's a feeling of being drunk and blacking out. Why couldn't he say that on the call? He can't tell her in the call. He doesn't want to tell her in a letter. But in the very next letter, he tells you about what his thoughts are. He tells you that all he wants to do is murder, murder. He wants to kill, kill, and kill. That's what he says. That dark thought. That's what he can't say to her until she's in person with him. Decisions and choices. I want to talk to you a moment about intoxication. That is not a defense to second-degree murder. intoxication, self-induced intoxication, which is what this is not a defense to second-degree murder. And furthermore, as to murder in the first degree, it's only a defense, if you find that he was so intoxicated that he couldn't form after deliberation and with intent. Let's talk about the things that show that he's really not as intoxicated as he'd like us to believe. At 2:20 in the morning, after he's arrested, you see him plainly in the video. You have it in evidence. You can review it. But you see him plainly get out of that officer's vehicle. He doesn't have help. He's got his hands behind his back. And according to him, they've stopped drinking at 1 o'clock. Remember that curve? That bell curve that Dr. Arnall showed you? He is not as drunk as he will be later because he stops drinking at 1. He stops drinking at 1. So he's supposed to be getting worse. He's getting worse. Sure doesn't look like he's getting worse. Not only that, but let's talk about the fact that he was running from the scene. He's running. And remember what Dr. Arnall told you? If he's running, he's thinking. He's thinking. And where is he running to? Where is he running to? He's running to Carol Butts Park. He's running in that direction, exactly in that direction, just up the street. That's where he's found. And remember what Ms. Cat told you? They used to go there often, together. That was their place. He's thinking. He answers questions for Detective Pardo. He answers questions about if he has any injuries. Nope, don't have any injuries. And remember, we have the photograph of him as well. Turned around, right? He gets there at 2 in the morning, and Pardo asks him to turn around. He doesn't fall, he doesn't stumble, his words aren't slurred. Why is that? Why is that? Well, the evidence is overwhelming that Mr. Galek is a drinker. He drinks. And not just one time, many, many times. And not only does he drink, but he smokes pot. He does both things. And he's been doing it for a while. And he managed to graduate from high school early, smoking pot and drinking. Why? Because he's gathered a tolerance for it. So when he climbed up those stairs, he was able to make those decisions and choices. Finally, let's talk about intoxication regarding when he is picked up underneath the truck. He's sober enough to know that if he's tased, it's gonna hurt. Because remember what the officers are telling you. They surround the vehicle. They're yelling at him, come out from under the car, show us your hands. Come out from under the car, show us your hands. Come out from under the car, show us your hands. Multiple times. And he does nothing. But when they yell to him, if you don't come out from under that car, we're going to tase you, whoop, he's out. He's out in the snap. He's sober enough to know that when he gets tased, it's going to hurt. And if he is that sober within minutes from the time of this particular event, If he's sober enough at this point, he was more sober prior. Because again, the 1 o'clock. Remember, stop drinking at 1 o'clock. So he's actually at less of a blood alcohol content. He hasn't started to peak yet. Briefly, I want to talk to you about the presumption of innocence. It's a presumption of innocence that the defendant receives, and our burden of proof, which is beyond a reasonable doubt. It's not beyond all doubt, ladies and gentlemen. Remember the testimony that you've heard. It's a common sense finding. You use your common sense. Does your common sense tell you that he confesses to a murder in a letter because he's depressed? Does your common sense tell you that? Does your common sense tell you he speaks in jail calls? About this event and doesn't understand what he did? No. We ask you to make your decision and choice and find him guilty of murder in the first degree.
Talk with you about how we see this evidence. I need to tell you at the start that there are many things that the district attorney and I agree about. Some of those things Ms. Warner has already talked with you about. Some of them have been that there's no question this happened in Adams County in the state of Colorado. It's not for you to decide. It's a given. Some of them are more serious than that, for there's no question that Hans and Beverly Winter are terrific people, and that Kevin Winter was Andy's best friend for many years, and that they treated him like family. There's no question about that. There's no question that even when Andy got off the rails and started smoking pot, that Kevin remained his friend. And there's no question when Andy stole from Kevin Winter, that Kevin Winter forgave him and remained his friend. There's no question that when Andy quit cello, Boy Scouts, those things, Kevin Winter remained his friend. And there's no question that after Andy Galek broke up with Melissa Catt, they became friends again, and they started their late adolescent friendship, and it started to anneal yet again. Those things are not for you to decide. It's a given. There are many things for you to decide in this case. And as I told you at the start, when we looked at this case, there are more questions than answers. I want to spend some time with you talking about the questions that we see. We are handicapped here, we are hamstrung, because generally in cases when a criminal defense lawyer gets involved, they ask the young man, "Did you do it?" And if the man says, "Yes, I did it," then we proceed in one way, and if he says, "I didn't," we proceed in another. But here, Andy Galek told me, as he told you, honestly, I don't know. I could have. I don't know. And as you read these tortured letters that the district attorney has talked about so much, you'll see a person struggling to try to figure out what happened here. He's a 17-year-old kid in jail, charged with a very serious offense, the most serious anybody can be charged with, and he's trying like hell to figure out what happened. How can I not remember? Did I do this? Did I hurt a man who's always treated me like a son? Did I kill somebody, or did I not? And so it's so serious that we don't know. And we even think about perhaps putting him under sodium amytal. Sodium amytal, it's a cousin of the drug fentanyl that we've read about in the news. Or Versed, for those of you who've had colonoscopies, it's a drug that puts people into a twilight sleep so that some people, clever questioners, can raise memories that are withheld deep in the brain. Now, there's some real dangers with that. People can die, and people can become in a persistent vegetative state, stay in a coma. And so on medical advice, we decided not to do that. But we were looking to that to try to resurrect this memory because we didn't know. And as I told you at the start, we trust jurors, and so we're going to have you help us decide what really happened here. So what do we know for sure? What do we know for sure? We know that there never has been a crossword between Hans Winter and Andy Galek. There never has been any difficulty, even when there have been rough patches in the friendship between Kevin Winter and Andy Galek. The parents stayed out of it, and they always treated him like a son. There's even the bed in the basement that they call Andy's bed. What do we know? There's been no crossword between Andy Galek and Beverly Winter. You heard Andy Galek talk about her and say that she's been nothing but nice to him. You've heard that from all the witnesses. There's no question about that. So why would Andy Galek go upstairs with a knife, stab Hans Winter one time in the belly, and then run downstairs? Why? If we look at it, what is there for Andy Galek to gain from this? What is there? What could possibly be his purpose? And so we hoped, because Andy can't tell us, we hoped that the crime scene police evidence would help us understand truly what happened here. What's going on here? And maybe there'd be some evidence that would tell us what this crime scene is about. And I need to tell you that the more we evaluate it, the more we come up with more questions. And let me share some of those with you. One, let's talk first, I guess, about Miss Warner's ninja suit. You know, the black shirt and pants and shoes. Well, of course, that's what Andy Galek wore over there. There was nothing unusual about that. He came over just like he always did, in black. He had on his black shoes and shirt like he always did. And they said hi to him, nothing unusual about that, and the boys went downstairs. I don't know if Miss Warner is saying that he had planned that and wore black so that later on in the evening he could sneak up. I'll be anxious to hear. The district attorney gets the last word. Perhaps Mr. Moretsky will explain this ninja suit stuff to you. I'll be anxious to hear that. But what do we know? We know that when Andy Galek comes over there that night, that he and Kevin are healing. We know that it was Kevin Winter that called Andy Galek to come over. That hadn't been planned. Kevin Winter called him on the text, I shouldn't say called, on the text, and said, hey, want to get blitzed? And there was some joke, I'm unfamiliar with that term. And then Andy Galek went to some friends of his at Kevin Winter's request, and they went and got this bottle of tequila. If I had more than 45 minutes, I could talk a great deal to you about this kids and alcohol scenario that we see, and this binge drinking, not just to get buzzed or drunk, but to get out of your mind or passed out. We don't have that time, but it's something we're seeing more and more of, and that's what was here. These boys didn't go to have a cocktail. They went to get enough alcohol to knock themselves out, and by God, they got it done. And so what do we know also that's true is that when Andy Galek gets there, he's in a good mood. And Kevin Winter says there's nothing out of the ordinary. In fact, he's in a good mood. He's graduated. He's going to get a job at King Soopers. That's coming up. He can get a car. He can move out of home. What every 17 and 18-year-old boy wants is to have some freedom. And they go downstairs and they play first Adult Swim, then some Halo, Kevin plays the cello after they start drinking. So it is a very cordial relationship. Good night, Andy. Good night, Kevin. And the Winters go up to bed. They watch Saturday Night Live. Beverly goes to sleep. Later, and we believe it's about just before 1:30, if you look at the times, Miss Winter says she wakes up hearing the shrieking. Why did you hit me, Andy? Now that's a question for us, because if you're wakened by a startled thing, it's what you remember next, not the startling thing that you remember because you're coming out from a sound sleep. And so I have a question about that. And then I have a question about that for, as I evaluate things, we put ourselves in the shoes of the people hearing this. Does it make sense that when Miss Winter hears this, she gets up and does not attend to Hans Winter, who is partially paralyzed? Do you remember her testimony? Miss Winter, did you go to Hans Winter to see how he was? No. Did you check to see how he was? No. Did you talk to him, honey, are you okay? No. What did you do? I ran down the stairs of the man that I saw. And again, depending on which time she tells it, either standing at the side of the bed or standing backlit by a light that hadn't been on out in the hall. And so she gets up, and instead of tending to, remember, he's a quiet man, and this is a terrifying shriek. She doesn't attend to him. She chases a stranger who she says, I can't see his face. I don't know who it is. Chases him down the stairs into the bedroom. Chases him down the stairs into the bedroom. Past the phone on the nightstand, 911. Past the phone in the kitchen, 911. Chases him down the stairs. When she gets down the stairs, she sees Andy Galek on Andy's bed and Kevin Winter on his bed. And here's where the details become important, because it's important what gets said there. Imagine that happening to you. What's the first thing you would say? What the hell's going on here? What does she say? Boys, have you been drinking? And depending on which time she talks about, and remember, thank goodness Detective Franca put most of this on a recorder, but even before that, he took careful notes at the start. And remember, Miss Winter and I had a great deal of discussion about what you said when. And you remember that it was only August 1st at the preliminary hearing that Miss Winter says, why did you hit Hans? Why did you hit Hans? For when she talks to Detective Franca at the scene, that doesn't come up. When she talks to Detective Franca on the videotape at the police department, that doesn't come up. It's only at the preliminary hearing, August 1st, that she says, Galek tells me, Beverly, I'm sorry I ruined your life. Now, would that be something you would remember if you were in the downstairs and heard that the first time? Is that something you would tell Detective Franca? Oh my God, he says he ruined my life and now I know what he means? But she didn't say that. She didn't say that. Neither to Franca, nor to Officer Russell, the street cop, nor on the taped interview. It was only August the 1st that that was said. And if you think back at the things we talked with Miss Winter about, there's this question. When she talks to Russell and Franca first, she says that Kevin Winter hugged me and said, it's all right. And when she talks to Franca on the 15th, after a while, she says, oh, and by the way, Andy Galek hugged me too, which is really weird because I've known this kid since first grade and he's never hugged me before. She didn't tell Russell that at the scene. She didn't tell Franca that at the scene. And remember what she told you? She wrote out a written statement. And we spent a great deal of time with that. It's in evidence for you to see. And you remember the district attorney saying, well, it's not all in there, is it? And she said, oh no. It's not on there because Officer Russell told me that I had to finish that statement before I could go to the hospital, and I wanted to go to the hospital. Officer Russell, did you tell her that? Oh, no. Would you tell her that? Absolutely not. And so we have a question as to what happens. That's a question mark as to what's said down there. Now, we'd like to have Andy Galek tell us. He can't remember. And not only can he not remember, but Kevin Winter says, I remember nothing. Kevin Winter says, I remember up to a moment. And then the next thing I remember, I'm sitting up at the hospital talking about Barack Obama and the politics. Do you remember anything that happened during then? No. So Kevin Winter can't help us. Andy Galek can't help us. Beverly Winter has told different stories different times. So let's look at what maybe the police can help us. Maybe the police can help us with this information. What do we know? Well, we start off with the police. We don't know if it's Officer Barron or Officer Russell, who's the first officer on the scene. They both say they were. So that's not a very good start. And when we get the police there, they don't cordon off the crime scene. They only have certain areas cordoned off. And so then we know that Beverly Winter is on the phone and people are coming and going out of that house. And so there's contamination. And so there's questions about what the evidence shows, but let's go back and see what the evidence is. Let us go to the bedroom. We know when Beverly Winter left, she says, to go downstairs chasing the stranger without attending to her husband, that he's lying on his back. Now, sometime in that period, she comes back up and recognizes that he's stabbed. Sometime in that period, she leaves him alone again. And not only does she leave him alone, but you heard the paramedics say when they got there, he's there by himself. He's there by himself, and he's there by himself, not laying down. He has seated up, and I don't know if somebody helped him or if he did it on his own, but he's seated up, seated at the corner of the bed with this stab wound in his left abdomen. And they try to talk to him, but at that point it's been too long, and so they scoop him up and scoot him to the nearest trauma center to get him treated. And so what do we know? We know from the crime scene investigation, from the pictures you'll see, there's blood on the bed. We know that's Hans Winter's blood. You heard the technical DNA person talk about it. We know that there's a pillowcase in the upper right hand and there's some blood on that. Do we know whose blood that is? Absolutely not. Do you remember Mr. Pardo saying, that's a pillowcase? He told Miss Warner, that's a pillowcase. And I said, did you want to check that? Remember what he said? And then you heard Miss Kadash saying, did you have any pillowcases to check? No, I didn't get any pillowcases to check. And even more serious, if you look at that foam pad, there's a blood smear on it. That means somebody smeared that blood, leaving DNA on that foam pillow. Was that collected? No. Was it even sent to CBI? No. Imagine if that was Andy Galek's DNA on that blood smear, then we know what happened. Imagine if it was someone else, then we would know what happened. We don't know. Another question mark. And so then also we have the case of the person who stabbed, who bleeds in the bed and on the pillow and on the pillowcase. There's blood on the knife downstairs, and yet the person who takes that knife, according to Beverly Winter, down 3 flights of stairs, there's not a drop of blood on that beige carpet. There's not a drop of blood on those beige walls. There's not any clear serum on those carpets. There's no evidence that that knife ever came there. There's no evidence that that was ever taken. Now, maybe that's the luck of the draw. You heard criminalist Pardo say, I looked on that beige carpet. That's a great medium for holding blood stains and clear serum stains. I didn't see anything. And so then we go to the bed, and you've seen the picture of the knife with Hans Winter's blood on it in Andy's bed. Now let's talk about some other questions. Because guess who's laying in that bed? Andy Galek. And he has to be laying on top of the knife, for you remember Beverly Winter never told you anything about seeing a knife in the bed. And Andy Galek, she says, is laying on that bed kicking the wall and those louvered doors. Imagine if there were, and you'll take a look at those boots, imagine if there's a print on the wall of one of those boots, that white wall, or a print on that louvered door or a broken louver. That corroborates that which she says. You'll look in vain for that. It's nowhere to be found. And you heard in Criminalis Pardo saying, there was some nicks on it, but looked like ordinary wear and tear to me. Detective Frankus says, oh, it looked like somebody could have been kicking him. I'd love to have those doors or have a picture of that, and then by God, we'd know if that actually happened or it didn't. We don't know. Another question mark, but what we do know is if Andy Galek is laying there to kick the wall, he's laying on top of that knife, a very foolish thing to do. But he's laying on top of that knife with Hans Winter's blood and clear serum on it. And you know what's funny? Do you know how much of that transfers to his clothes? Remember what Miss Kadash said? I looked at those clothes, not a blood speck or a clear serum. And you know how much of it transfers to the bed? Not a lick. Or Investigator Pardo did not collect those to determine. Now maybe that's just another unfortunate thing. Just like there just didn't happen to be any evidence in the bedroom that says Andy Galek did it. Just like there happens to be no blood stains on the stairwell. Just like there happens to be no transfer on Galek's clothes or Galek's sheet that he's on. Maybe that's just another coincidence. And so then we go even a little farther. We go even a little farther, and we have what Beverly Winter says is that Andrew Galek gets up and runs out of the room. She chases him. She goes back up the stairs. And remember what happens in the kitchen. And again, I wish we had some scientific evidence to talk with you about. It would help me understand this case, and I suspect you as well. She says he goes to the kitchen and that there's no reason for him to know where they keep their knives. He opens up the first drawer, looks in there, closes it, opens up the second drawer, and takes a knife out. It's the sister knife to the knife that's in Andy's bed. Why, if you wanted a knife and you were laying on a knife, wouldn't you take that one if that's what you wanted to do? Why, if you had taken that knife from that drawer earlier, we don't know where that knife came from, but Beverly Winter said everything's either in the drawer or the dishwasher. If Andy Galek had taken that knife previously, why wouldn't he go back to the same drawer? And third, remember what Miss Winter said? Those mug root beer cans, they weren't there when I went to bed, and neither was that third knife. I'd like to know whose prints are on those mug root beer cans. That's yet another question. Imagine if it was Andy Galek's. That would help us. Imagine if it was someone else. I'd like to know whose fingerprints are on that knife. But we don't know. Because nobody briefed Criminalis Pardo and told him those hadn't been there when Beverly Winter went to bed. And so we'll never know. Yet just another question. And then we go to the run. Remember, Beverly Winter said that she had locked the door when she went to bed at night, and that's a key lock. And when she went up, she went and opened the door. By God, the door's open, and she was happy that that's the case, because she could. Now she's getting frightened. Here's Andy Galek, she tells us, with the knife. Apparently she hadn't been frightened before with the terrifying shriek of her quiet husband, Mr. Winter. But she holds the door, and Galek runs out, according to her, and runs through the gate. Now, who opened that door? I would really like to know that. That's yet another question. Who unlocked that door to make it available for Beverly Winter to open? And then, even more curious, We have Miss Tarrant. Remember Miss Tarrant who spoke Spanish and was interpreted? She says, it's 1 o'clock in the morning, and I wake up. I'm watching TV, I'm laying on the couch, I hear a sound, and I look out, and there's 2 boys. And she says, one of them is Andy Galek. And the other one has on a maroon shirt. Maroon shirt. Curly hair, maroon shirt. And they're horsing around. And they're laughing. And they're talking loud. And when a truck comes down, they hide beneath the bushes. Now, if that's Kevin Winter, I'd like to know that. If it's someone else, I really want to know that. Let's assume that it is Andy Galek, though. Let's say that there's no evidence it's not Andy Galek. Let's make it Andy Galek. Now, we know Andy Galek is out with those boots on. We know he's out late July 12th, early July 13th, walking around the street. Now, you know that there's dirt in the street, and those street dirt is on his boots, so if he had kicked the wall, you can bet that pattern would be there. What does Miss Tarrant tell you after that? Well, she says, just around 1:30, I hear the boy come out. The boy she thinks is Andy Galek, most likely is. And what does the boy do? He comes out and he's talking to himself. And he's saying, fuck, fuck. And what does he do? He lays down in the median. Maybe falls. I could never quite understand if she said he fell down or kneeled down and laid down. But he lays down in the median for a bit. An unusual thing to do in July, in the middle of the night. And then he gets up and starts walking towards her house. She becomes so frightened that she calls 911. And he goes on down the street to Carol Butts Park. Now, why would a person do that? A person, remember, there's an evidence in your instruction packet called flight. And laying down in the median is the last thing from flight. It's not getting away from someplace. It's hanging in the median waiting to go on. And then he walks down towards Carol Butts Park, and then, you know, Denise Owen sees him, and he's got this goofy run that she sees him, and then he hides underneath the truck, but not a very good hide. All right. So what do we know back at the crime scene? Well, we know, according to Dr. Arnold, that that knife stab goes in farther, and we know from Mr. Pardo it goes through a blanket and a sheet. And we know from Miss Kadash that there's touch DNA. And so if the person who had the knife here, and this were the sheet, and they drove it through the sheet, then that part of their hand would touch the sheet. Now we know that if you wash the sheet, the DNA comes out of it, but there's been no evidence those sheets were washed. And that Pardo collected them very carefully, photographed them very carefully so that that evidence would be available. What do we know from that evidence? I'm not even going to talk with you about the 99.99 and all the nines we talked about. I'm going to talk about the only time that Miss Kadash said somebody was completely excluded. There's DNA on that blanket, and it's Hans Winter for sure, probably Beverly Winter, because those are the parents of Kevin Winter. It could be Kevin Winter, but absolutely 100% Andrew Galek is excluded from depositing that DNA. Well, maybe that's just another coincidence. Just like no blood, just like those other things that we've talked about. Maybe that's just another coincidence. But you can see how those coincidences start to add up and give me nothing but questions. Now we know that when Andrew is arrested, he's underneath the truck. If that's a hiding place, not a very good hiding place. And we know that he's very intoxicated. Now you heard Miss Warner talk with you about, well, there's intoxicated and intoxicated. But let's go to the experts, the street cops first. Detective Frankie, you put in your report he was very intoxicated. Took me a while to get that, but he did put it in the report. Officer Hopkins, you smelled a strong odor of alcoholic beverage, didn't you? Yeah, and remember when he testified with the government, the district attorney said he was a little unsteady. But when we have him his report, he said, oh, I guess I did write very unsteady when he sat down. And that's what I remember now. And so there's little question that at the time Andy Galek is arrested, he is very, very drunk. Even if you do Ms. Warner's discussion of the curves brought to you by Dr. Arnall, an absolute hotshot who wouldn't give either one of us an answer that we wanted if he didn't think it was true. He says, if he quit drinking at 1:30 exactly, it's .186. Even if that's the time that the curve is moving, 186, at least 2 times the level of alcohol considered safe enough to drive a car. And most likely .198, so it's between 198 and 186. That's a huge load of alcohol for somebody to carry, and clearly intoxicated. Even the scientific tests they took, the 150 and the 138, Dr. Arnall, is that 138 intoxicated? Absolutely. 150, you bet. 198, of course. Now imagine if this were a vehicular homicide where a drunk driver had killed someone. Do you believe the district attorney would be telling you an experienced drinker ought to be able to drive that car? Forget about the scientific tests. We all know, and the evidence shows absolutely, that Andrew Galek was drunk. And we know that when he got to the police department, he was able to get out in the sally port. Take a good look at that film. You'll see him stumble into the sally port. The officer takes him by the arm, takes him in the door. And we know that while Pardo didn't smell any alcoholic beverage on him, we know that Officer Hopkins did both before and after Pardo was there. We know that Detective Infranca went and saw him after Pardo left, and he smelled a great odor of alcoholic beverage. And we know from Detective Infranca that they had to stand him up because he was falling down and sleeping. And we know that when he got to the juvenile detention center, he didn't know why he was there. And so we have more questions here than answers. I wish I could tell you what some of the answers are, but we give it to you to decide. Now I need to mind my manners. This has not been a very easy case. It certainly hasn't been for me, and as we've watched you, and you know we do. We watched you and we could tell that you all paid strict attention to some very technical information from Ms. Kadash and some tough pictures from Dr. Arnall. We've watched you pay attention, and that's your duty. But on behalf of Andy Galek and the Galek family, I want to thank you for that. In the end, we need to figure out what really happened here and what we really don't know. This case comes to you as a first-degree murder, a second, a manslaughter, and a criminally negligent. That has been defined for you in the circumstances. Think about why. What's this all about? Is it Miss Warner's position that Andy Galek dressed up in a ninja suit and came over planning to kill Hans Winter for reasons that are yet unknown? Was it even Andy Galek? I wish I could tell you, but we don't know. When I'm done speaking, the defense of Andy Galek is over. No one will speak for him again. The district attorney, if they believe it's necessary, and I think they will believe it's necessary, get a chance to answer what I've talked about. I will not speak again. That's the law. They have the heavy burden of proof, and so the law gives them not only the first, but the last word. That's as it should be. But I'm interested in hearing what Mr. Moreski has to say. I'm interested in hearing him answer this question, why? Maybe he'll tell you why it is that Andy Galek's DNA is not on this sheet. Maybe he'll tell you why there's no blood drops. Maybe he'll tell you how it is there's no transfer. Maybe he'll tell you why Andy Galek is drunk one moment with Officer Hopkins but not with Mr. Pardo. I'll be anxious to hear that. I'll be anxious to hear what that has to say. Irrespective of what Mr. Moretsky says to you, when you go back in the jury room and you think about what I might have said, you'll know the answer. You'll know the answer to what I would have answered. Ladies and gentlemen, on behalf of Andy Galek, I now ask you to take this evidence and these instructions, go back and look at them, and help us provide the answers that both of these families need. Tell us what happened. Thank you.
Mr. Moretsky?
How much time do I have, Judge? How much time do I have?
19 minutes.
Ladies and gentlemen, Mr. Truman is a skilled and eloquent attorney. And of course, he's going to stand in front of you and tell you there's questions about everything. What I'm afraid of is that with the 19 minutes that I have, that I won't be able to explain to you why Hans Winter is no longer here. Hopefully the evidence has showed you that. Because after I sit down, no one gets to talk for the family. No one gets to talk for Hans Winter. And honestly, you have to use your common sense. You promised as jurors that you'd do it. And you know what? He's very, very eloquent. And I sat there and listened to him, and I have to say he's great at that. But this case isn't about how good an attorney he is. This case is about the facts. And when you look at the common sense, notice the things the defense counsel didn't say a word about. Didn't say one thing about. And that's the confession. And that's exactly what this is. Innocent people don't write letters to their girlfriends saying, how did I pay back Kevin Winter? I stole from him, I ditched him for you, and I stabbed his dad. You don't need to know anything else about whether or not the defendant's story from the stand was credible or not. If he knows he stabbed him, he knows what was going on. Ladies and gentlemen, I would never stand here as a prosecutor or an attorney and tell you that the defendant was not drunk or intoxicated that night. That's not the question. Of course he was past the legal limit of intoxication. But don't confuse those things. Don't confuse them. Just because you can't drive a car doesn't mean you can't think. You have to be so drunk, so intoxicated, that you can't deliberate about something, that you can't form intent. And we talked in voir dire about deliberating and intent. Talked about how you can do that in a split second, or how you can do that after a long reflection period. This isn't the case. This isn't the case where the defendant couldn't think, and you promised as jurors to use your life experience and your common sense. And I would submit that every person in this courtroom has dealt with a person who's been drunk enough who couldn't deliberate and couldn't form intent. And when you see that person, you know it. And when officers who deal with those kinds of people on a daily basis see those people, they know it. And that's why we ask the questions. We ask the question specifically. With these people, was this person, Andrew Galek, was he responding appropriately? Was he saying things to you, like his address and the other things? Was he acting and appearing to understand? Yeah. Why do we ask those questions? Because it's the most important question you have to ask. I don't think, it doesn't matter what I think, but honestly, this case isn't about a negligent homicide. This wasn't somebody allowing their child to go play with a gun and something happening. This wasn't somebody saying, oh, gee whiz, I should have known better. This was about a person intentionally going into a room and stabbing another person in the middle of the night. It's not reckless to do that. It's intentional. You don't trip and fall into the bedroom and stab a person. But you've all had to deal with the situation where there's an intoxicated person who's so intoxicated. And remember, that's what it has to be. It has to be so intoxicated that they cannot form intent or after deliberation. What does that person look like? That's a person who's outside the bar, hugging the lamppost because he thinks it's his girlfriend, who's talking to his buddy saying, hey, look at this is my girlfriend. That's that person. That's not what we have here. Moments after this crime is committed, he realizes what he's done. And how do you know that? You know that because he runs and he cries. And think about, for a second, trying to relate a story that when it happened, you didn't know that, the person didn't know, Beverly didn't know that her husband had been stabbed at that time. And then when she found out, the awesome responsibility and the emotions that are flooding through her when she's trying to write a statement and tell the officer what happens. So she gives him the outline of what's going on. And then she sits at the table and tells the officer a little bit more. And then they interview her and they go through it. And they get as much as they can. I'm actually quite incensed right now because he is such a good attorney that what he said, and I need you to focus on it, what he said and what he didn't say. Because if he had stood up and said, you know what, Kevin Winter or Beverly Winter committed this crime, that would be offensive. That would be offensive to the evidence that's in right now. But what he did is tantamount to that. What he told you was the implication of that, which was Beverly's DNA is on there and Kevin can't be excluded. Well, you also heard me ask other questions, like the tequila bottle of the defendant. He touched that tequila bottle too. And they didn't get that DNA, did they? No. So what does that mean? That his hands just weren't producing DNA. So when he plunged that knife into Hans Winter, he didn't leave DNA. I wish he would have, just like counsel said. But what we have next, your common sense tells you, is just as good. We have the victim screaming out, Andy, from the very beginning of this, from the very beginning, the first things, Andy, why did you hit me? We have Beverly Winter, who, ladies and gentlemen, it's insulting with the evidence here would be suggested that she would actually have anything to do with this. Listen to the 911 tape. Beverly Winter, who follows the defendant downstairs and sees him in a state of emotional distress. When he says, I'm sorry, and we went through that transcript a bunch of times, went through it on purpose, who says, I'm sorry, and she does report that to the detective in the first instances. But she believes it to be, because she doesn't know that he's stabbed at that point, she believes it to be about the alcohol. So that's the story that she's relating. She follows him then upstairs, where is it disputed that the defendant had a knife? I guess I'd like to know if that's in dispute or not, because he takes a knife out of the drawer. Why get a knife? Why say to Beverly, I'm not going to hurt you? Why didn't he take the knife on the bed? Well, because he had realized exactly what he had done. He had said, I ruined your life. Yeah, that's a stunning fact, isn't it? Killing somebody isn't as easy as it is in a video game. When you get interrupted, when you stab them and they scream out, you're caught. People don't die instantly. And when you pull that knife back out and you followed and you realize that you're caught, when that mental realization hits, and it's somebody that you do care about because you've lashed out in whatever anger or demon that you have, and you realize the ramifications of it afterwards, you distance yourself from what that is. So yes, he puts that on the bed and leaves and runs, tries to get as far away from what he's done as possible. He follows upstairs. He gets a knife. And you heard Beverly Winter say that knife wasn't damaged. So what's he doing? He's mad, he's stabbing, breaking that knife off because he knows that he's ruined his life. But not only has he ruined his life, He's ruined theirs. After deliberation, you'd have to say, is there deliberation in this case? Take you through every single step of this case. The individual who's thinking about this, the defendant, had to do some things. We know he took his shoes off, Kevin Winter. And the defendant told you, these people, he has no reason whatsoever to disbelieve what they're saying. And they're telling you from the stand. Kevin Winter told you they took their shoes off. They took their shoes off. He had to put his shoes back on. He had to wait until everyone was asleep. He had to walk up a flight of steps, walk up another flight of steps, turn on a kitchen light. Look at the photographs. The kitchen light is on. And how would you get backlit? Because the kitchen light just down the stairs in the hallway is on. So the light from the back hallways up the steps. You turn the kitchen light on. Then what does he do? He goes to the drawer. It's not his house. Goes to the drawer, finds a knife. It's demons acting. He goes upstairs. Does he stand over Hans Winter's bed as he did Kevin's bed that he said he remembered? We don't know that. But what we do know is that he plunged a knife into Hans Winter and was caught because Hans Winter didn't die immediately. And if you look at the angle that this went in, I'm going to submit to you, ladies and gentlemen, that Hans Winter wasn't laying down flat on his back. What he was doing was laying on his side next to his wife with his back to the defendant. And what the defendant had to do, remember the defendant's word, he was so drunk and dizzy he was stumbling around. He snuck into the room, he was stealth enough to do that. Snuck into a room, plunged a knife into a paralyzed man who was sleeping. And when that man who was paralyzed didn't die and called out his name, he ran. And how do you know that Andrew Galek did these things? The evidence tells you, Beverly Winter tells you, but Andrew Galek tells you that he stabbed Hans Winter. You know, Kevin Winter tried to drag the defendant into a different life. You heard the testimony. Everything that Kevin Winter did, that the defendant followed. Kevin tried to get him to do different in school, tried to get him to go to church, tried to get him to do Boy Scouts, tried to get him to do cello, tried to get him to do the IB program, tried to get him to go to college. Those were all choices he made not to do. Nobody could drag him there. Why? Well, he tells you why in the letter. You'll have to read that. Even when Andrew Galek decides to hang out with the party crowd. And think about that for a second. What is it that hurts the defendant in this case? What is it that he knows is going to hurt him, and he told you he knew it would hurt him, is if he was a tolerant drinker and he was good at it. Well, I asked him about the party group and everything else. What did he say? Oh, no, it was just marijuana mostly. But he drank until he blacked out, and he drank until he blacked out again, and he drank until he blacked out again, according to him. Now, according to Ricky Meester, this party group got alcohol and pot all the time. It's your decision to determine credibility there. But he said it was much harder to get alcohol than it was marijuana, so they didn't smoke, or they didn't drink alcohol as much. But yet when I asked them when they wanted alcohol on that night, how long did it take them? 30 minutes. They got alcohol whenever they wanted. This was a party group. They were drinking. He would bring alcohol to school. This is a person who was a practiced drinker. Put all of those CDs together. Listen to the 911 tape. Listen to the call. Beverly's reaction. Why, if Beverly had had anything to do with this, would she leave the person who could say something alive? She got separated because she had to open the door for the police officers and didn't get a chance to go back to her husband because they had to clear the house. Thank you, Judge. Nobody here says that the decision that Andrew Galek made was a good decision. This isn't the product of good decision. This is a product of alcohol. We don't dispute that. The only question is, was it a product of him not being able to think about what he did, deliberate, and intentionally do it? He wasn't to the point where he couldn't deliberate. He had to deliberate. He didn't go into the kitchen and grab a rolling pin and walk upstairs and try to stab him with a rolling pin. He got the implement of death. He got a knife. He got an object he knew would accomplish it. If you can think about what it is you need to get to kill someone, that's deliberation and intent. You have to ask yourself, is his blackout something that's true, or is it convenient? Because he remembers only those things that basically help him, and conveniently forgets, doesn't remember those things that hurt him. Kevin Winter just didn't remember any of them. Kevin Winter and Ricky Meester, those individuals, told you about how he was with his alcohol. He's a practiced drinker. And you look at the Sally Port, and you listen and remember what the officer said about how he was responding appropriately. We're not saying he wasn't drunk, but look at that and tell me if that's the guy who's falling down drunk that he reported himself to be, that he was blacked out. And that was only 30 to 40 minutes after this event. And he was responding appropriately. Think about the things he said. Did anything happen at the house? No. How'd you get here? I don't remember. Convenient. Remember that you promised. You promised that this decision would not be based on sympathy because of anybody's age in this case. And you promised to use your common sense. And I'm going to ask you and hold you to that. Because what I'm going to ask you to do is replay every single event in your mind, every single one of those facts, and then change one fact. And that one fact is, instead of being him, imagine this individual as a 35-year-old man. And if that changes anything in your head, you have to put that out of your mind. Because murder, ladies and gentlemen, and the choice to murder is an adult action. It's an adult decision, and it's something he made. And ladies and gentlemen, I started this with telling you that I don't believe that my skill should have to be what's judged here. I hope it isn't. Because you know what? You, as a jury, can never do justice in this case. Justice would be that Hans Winter, a brother, a father, and a husband, who by every single account is a loving, giving, caring individual, would be here and be brought back. You can't do that, and I can't do that. You can't do justice. But what you can prevent is injustice. You as a jury can prevent injustice by telling the defendant, as he sits here, that the presumption of innocence is now gone because the evidence is in, and he's guilty beyond a reasonable doubt. Ladies and gentlemen, prevent the injustice. The defendant is guilty of first-degree murder. Thank you.
Do you swear or affirm under penalty of law that you will, to the utmost of your ability, keep this jury together in some private and convenient place, and that you will not permit any person to speak to them, nor speak to them yourself, unless by order of the court, except to ask them if they have agreed upon a verdict, and that when they have agreed, you will return with them into court? All right, when we selected a jury, we added 2 jurors as alternates. Those are the jurors in seats number 13 and 14, who would, if necessary, take the place of any juror who could not continue to participate due to illness or otherwise prior to the beginning of deliberation. The law does not, however, permit the alternates to deliberate with the other jurors, so I'm going to ask that jurors number 13 and 14 remain in the courtroom while jurors 1 through 12 go into the jury room, and I'll speak with you a little further once that's done. You may take your notebooks, and I'm speaking to jurors 1 through 12. You may take those into the jury room with you. Do not take them anywhere else. after retiring unless specifically instructed to do so by the court. Please do not begin deliberating until all of you are together in the jury room and all the exhibits admitted into evidence have been delivered into the jury room. You may discuss this case only when all of you are present, and you may only deliberate in the jury room. No juror should attempt to discuss the case with other jurors or anyone else at any time other than when all 12 jurors are together in the jury room. I will again caution you not to attempt to conduct your own investigation of any facts. Do not consult dictionaries, law books, or any other sources of information, including electronic. Your verdict must be based solely upon the evidence admitted in this case. Ms. Alatorre, if you would escort jurors 1 through 12 into the jury room. All right, jurors 1 through 12 are now in the have been escorted into the jury room. And I'm going to ask the counsel approach for just a minute. We need to discuss one thing. All right, folks, in Colorado there are circumstances wherein an alternate juror may deliberate. And those circumstances would be somewhat as follows. Within a reasonable time after the jurors begin their deliberations, for example, a juror may become ill, or some other reason they are not able to deliberate with the other jurors. Under those circumstances, again, within a reasonable time, and that is the reasonable, I suppose, is something that the court has to determine. One of you or both of you may end up deliberating with the jury. In that event, what they would have to do is forget everything they've talked about and start all over again. And you can see the difficulty with that, but that's the law, and I'm going to ask you to be back here at about, gosh, I'm going to say 1 o'clock. It's a little before 11:30 now. And I do not want you to discuss the case either amongst yourselves or with anybody else during this period of time. It's just like things were before. At 1 o'clock, I'm going to revisit the issue with the attorneys, and we will make some determinations at that time. But remember, don't form or express any opinions yet. I know it's a difficult instruction to give to jurors, but there is certainly a possibility that one of the two of you or both of you may end up deliberating in this case. So what I'm going to ask you to do, and have Ms. Alatorre when she gets back in here, if you have cell phones or something like that, perhaps when she returns into the courtroom, I'll just have you write those down for her, and then if there's some reason we need you before 1 o'clock, we'll let you know. But other than that, we'll just plan on having you back in here at 1 o'clock, and I'll wait till she gets back to have you jot down your notes. All right, everybody's here. The court will go back on the record in 08 CR 2007. Mr. Galek's here, Mr. Truman, Ms. Warner, and Mr. Moretzky for the people. Off the record, I read the requests/questions of the jurors. They wanted highlighters. Those were provided. And then the next thing that's written is playing the CDs, a device. Need CD player or transcripts for 911 call and telephone calls between defendant and Melissa Cat. And underneath that is need DVD player for Sallyport videos, signed by the foreperson. This is how I propose to answer the question. That will be instruction number 18. I have case number and the name of the case. Response to jury question. I should say request. request number 1. The court will provide a computer to display the compact discs and digital video disc. Underneath that, I write transcripts taken by the court reporter of evidence or testimony during the court proceedings are not available. You must rely upon your collective memories.
Perhaps, Your Honor, another paragraph, you have received, to stop additional questions or requests, you have received all the information the court can give you.
I'm going to say you've received all the evidence that you may properly consider in the case.
That's fine.
All right, here, I'll just print one for everybody.
And I think we also should probably make a record that it's in the
Oh, that's right. We did have a discussion before the jurors went in. I think counsel and the court reporter went over all the exhibits, and somewhat surprising to me, my notes were right. Exhibit 95 was not admitted, so there is no Exhibit 95, although the other exhibits, that would be 1 through 115 minus exhibit number 95, 133 and 134 were admitted into evidence, and the jurors have them.
We agree.
All right, folks want to come up and take a look at these. I'm just going to, I haven't numbered these, but I'm just going to number 18. All right, the only additional thing I put on number 18 and sign my name.
Just so counsel, where I'm bringing this up to the jurors from downstairs, so this year we're 12
All right.
Thank you, Your Honor.
Thank you. All right, the court's going to recall 2008 CR 2007 People of the State of Colorado v. Andrew Galek. Mr. Galek is present with his counsel. The district attorney's office is present. The court a few minutes ago received a jury question, and it's, yeah, I suppose it's correctly termed as a question. It reads as follows. Jury requests explanations or definitions of recklessly, knowingly, deliberation, intent. Jury.
right now. Okay.
You have another one? Jury requests analogies, examples for each definition. EX period. Analogy was given Ray reckless. Knife explanation following with. Okay. Any suggestions on behalf of Mr. Truman and on behalf of Mr. Galek, now by Mr. Truman?
Your Honor, it's my recollection they've been given definitions concerning those exact terms. I am hesitant to provide them with any analogies. So I think they need to be redirected to the numbered objection or numbered instruction that has those definitions.
The computer that we have, they both play exhibit number 115. They got the other two, they listened to the other two, but they both play exhibit 115. They're just the phone calls or whatever.
All right.
But they just have something.
Okay, something else to talk about. All right, what are the people's thoughts with respect to the rather, and I can tell you, I don't feel it would be appropriate whatsoever to give the jury analogies, because
That's the only thing I think we can do is direct them back to the specific instruction and definitions of those particular elements.
well, this is my only concern. Looking back at the old Leonardo v. People case at 728 Pacific 2nd, 1252, Supreme Court case from 1986. And I suppose this isn't exactly analogous, but there the jury asked the question whether knowing or believing meant the same thing as having a suspicion of for the purposes of theft by receiving. There they found it was reversible error to simply refer the jury back to the original instructions, reasoning that the jury had examined the original definitional instructions and found them confusing, and that referring them back to those would serve no useful purpose. There's People v. Fell at 832 Pacific 2nd, 1015, 1991, where they ask about terms as far as the statutory definition of sexual penetration. There, the court found it was an error not to, well, it was an error to refer them back to the instructions because apparently they didn't understand them. And People v. Atkins at 885 Pacific 2nd, 243, the Court of Appeals noted that when a jury requested definitions of custody and confinement when dealing with escape, it was an error for the trial court not to provide existing legal definitions that had not been previously supplied, and I guess that shouldn't be the case here. But the Leonardo case is the one that causes me the most pause, I suppose. But I just don't know, mainly because all of those definitions are statutory definitions. They're not, and I thought knowing or believing was a statutory definition as well, as it was in the Leonardo case. But my thought would be, I suppose, if it weren't for that case, it would be simple. I just point it back to the definitional instruction of the culpable mental states, and those are in instruction number 14.
Your Honor, I think the Leonardo line of cases tell the court that if you can help the jury, you ought to. And that is that you've received all the law and instructions and evidence you're going to now decide. After Leonardo was no longer appropriate. I think that's where Leonardo got in trouble, and the court didn't answer the question about believing and knowingly. Knowingly, of course, being the statutory definition, believing being something less than that. Here, I think that the jurors have asked for statutory definitions or analogies. I don't think we can go outside the statutory definitions, and I certainly don't think the court can give analogies concerning those items. I'd be happy to do so, but I don't think it would be appropriate.
All right. Ms. Warner, Mr. Moretsky, anything to add to, and I suppose the believing thing in that by receiving, that's a little bit different in that crime is a little bit different because even if it isn't stolen, if you believe it is, one could be culpable for that offense. But what do you think?
Judge, I believe that I think we're all on the same page. I don't think it's appropriate to give the jury analogies. In regards to whether or not we should give them the definitions, there's only two choices. We either direct them back to the specific instruction and say as the instructions, or we give them an entirely new instruction with the exact same.
Yeah, that wouldn't serve any purpose. All right, let me draft an answer for them. All right, this is what I've drafted. This will be instruction number 19, People v. Galek, 08CR 2007. Response to jury question/request number 2. The court may not provide analogies. The court will direct the jurors back to jury instruction number 14, defining the culpable mental states. Any objection to that response?
None by the people.
None.
Next issue. Exhibit number 115 will not play on the computer.
I don't know if the court wants to take that laptop out of the jury room and bring it to the 115.
Well, you know, the only way that I can do that if we're talking about a non-pristine computer, because I know it wouldn't be anybody's fault, but, you know, who knows what's on somebody's laptop. You know, as I mentioned earlier, all that needs to be done is somebody pushes the wrong button and they're into your trial strategy or something of that nature. So with that in mind, about the only way that the court could and the way I've dealt with this before, despite the time, and I'm not blaming you folks because I keep telling your cohorts about this, but apparently they're not relating it back to you guys. You know, when we have evidence of this nature, the jurors get to see it, and I can't send it back with something that might contain a bunch of information. It'd be like me sending a instruction number 19 back inside of this book. And but the only other way I could figure out maybe to do it would be to allow them to perhaps have Miss Alatorre an instruction that they're not to discuss it while she's in there, and she'll play it once from beginning to end. Take the laptop back out. If they want her to come in and play it again, she'll play it again. I don't want her interfering in the deliberations or even hearing them. So that's the way I've dealt with it in the past.
Judge, I guess my suggestion is, I don't know if they're just not doing something right with the computer. You suggest taking the exhibit and the computer that the court's giving, having the court look at the file to see if the file will actually play on the court's computer, not us giving it on the computer.
All right, I guess we can give that a try.
Either way is fine with us. I trust Ms. Alatorre to go back there and see if it works.
All right, you want to grab the whole kit and caboodle and bring it out here and see if I can get it running, and then we'll send it back to them.
Do you have a question?
Yeah, you did something crazy today, though, like, what? Oh.
All right, this is what I did. Just so folks know, this is the way I worked my way through that one. Rather than just clicking on the icon that Windows Media Player, I went to my computer, went to the DVD that came up on there, and then there are the 1, 2, 3, 4, 5 snippets that are each not specifically identified. They just have a bunch of numbers and the size of the file on there. I clicked on that and it played. With the permission of counsel, I will leave this, leave it set as is right now. It just has the small icons for the Windows Media, along with some information that just reflects the dates and the size of the file and things like that, and have Ms. Alatorre tell them just click on these.
People have no objections to that.
None.
Okay.
Do you want me to stand there, or is it okay to just?
No, if you just tell them they just
Okay,
need to
click on.
double click on the icons. They're in there. Here, got a little something extra there.
No, sorry.
Okay, I think that's all we have for now. Court will be in recess. All right, the court will recall 08-CR-2007, People of the State of Colorado v. Andrew Galek. Mr. Galek is present with his counsel. The district attorney's office is present. Approximately 5 minutes ago, the court was informed that the jurors had reached a unanimous verdict. Are we ready to receive the verdict?
The people are judge.
Ready?
All right. I'll simply note that I expect there are high emotions, as there are in these kind of cases, from both families, and I expect that. However, I also expect folks to conduct themselves in an orderly fashion in the courtroom. So I will ask that there be no outbursts or anything of that nature when the court reads the verdict of the jury. Bring the jurors in. All right. The jurors are back in the courtroom and in their seats in case number 2008 CR 2007 People v. Andrew Galek. Based upon the fact you're carrying the paper, I will assume that you are the foreperson of the jury?
Correct.
All right. Has the jury reached a unanimous verdict?
Yes, we have.
All right. Ms. Alatorre, if you would please collect the verdict form and interrogatory from. All right. If Mr. Galek will stand and receive the verdict of the jury. Jury verdict, count 1, murder in the first degree. People of the state of Colorado v. Andrew Michael Galek, defendant. There is a signature of the foreperson beneath Roman numeral number 2. We, the jury, find the defendant, Andrew Michael Galek, guilty of, and there's a X in the box that designates murder in the second degree. You may have a seat. Do counsel request that the jurors be polled?
No, Judge, nothing.
I do not, Your Honor.
All right, ladies and gentlemen of the jury, I want to thank you for the week of service you've given to the citizens of this community, and I mean that sincerely. You all paid close and careful attention to the evidence in this case, some of which I expect was difficult for you to listen to and observe. But you've done your duties, as I mentioned earlier, other than perhaps military service, voting. There's no service as great to the community as jury service. You've taken important time out of your lives, from your jobs, from your families to do this, and I appreciate it. There are countries all over the world where people are fighting and dying for the right to have a jury trial. And in order to have jury trials, we need citizens that will come forward and act as jurors and listen to the evidence and deliberate. You have completed your duties as jurors in this case and are now discharged for the thanks of the court. The question may now arise of whether you can talk to anybody about your observations in the case or what went into your deliberations. And my answer to you is relatively simple. If you want to, you can talk to people as much or as little as you'd like about your observations of the case, your impressions, or what went into your deliberations. That's up to you. However, I will tell you that if anybody persists in talking to you over your objection, I want to know about it. And I'll take care of that. Furthermore, if anybody is critical of your service as jurors, in this case, I also want to know about that. Many times after a trial, the jurors, and I do this with an open door. If you wish to speak with me, once you're released, you're welcome to. As I instructed you, you can talk to people as much or as little as you would like to about your thoughts about the case. If you have questions for me, there are some I can answer, some that I can't, because I'm still a judge in this case, and there are certain things that I just am not allowed to talk about. And I also invite suggestions. And I say suggestions because I know that everybody took important time out of their lives, and there are probably other places you would have rather spent your week. But we try to make this experience as painless as possible. And jurors make suggestions to us all the time, and there are some that we can accommodate and make the experience better for the jurors that come in the future. With that, I'll thank you once again, and thank you for your patience. I know we had some delays, and they were just unavoidable. I can tell you that everybody was working very hard to get this case to you in an appropriate period of time. Ms. Alatorre, if you would please escort the jurors outside of the courtroom. Folks, and I'll inquire of counsel, at any sentencing hearing, the court certainly gives latitude, and it has to under the VRA with respect to folks that want to speak to the court at the sentencing hearing, and also would certainly listen to folks if they want to speak on Mr. Galek's behalf. The question becomes whether I should set this on a normal morning docket day or perhaps on a Friday afternoon. So if there are going to be a number of folks that want to speak, I can better accommodate the time constraints that the court has.
If the court would indulge us, we would ask the court to do so, to set that for Friday.
Friday afternoon would seem to be a wise choice.
All right, that's what we'll do then.
Would ask the court for a pre-sentence investigation.
And the court will order a pre-sentence investigation report.
September 25th at 1:30.
September 25th at 1:30.
That's fine with the people. Thank you.
Fine with that.
All right. The sentencing hearing will be held on September 20. Oops.
Jared, perhaps we could look at the 18th.
Judge, I don't think that we can do that. Could we go move it into October? The 18th is okay? The 18th is fine if that's okay with the court.
1:30.
All right. We'll make it the 18th of September, 2009 at 1:30 in the afternoon. Mr. Galek, once he's done speaking to his counsel, will be remanded to the custody of the sheriffs.
Thank you.
Court is adjourned.